She's at this point, I'll take care of my brother's work over this. That's the reason she gave me.
By the way, speaking of that, but I just, on Monday, I just got my. She said she goes back. They're looking for free.
Yeah, I've been,
So I had
for decorating.
Yes.
Really? Yes, that's right.
Yeah. You didn't pass the board? I was wearing. And some of my ancestors are very experienced. Yes, and I must have. I should. I mean, everybody's. There's just random birds. Well, there's a number of. And I think she said, on my father's side, which is the Gaussian side, his family parents are ambulance, and she showed us some ambulance on her. And right up my I have birds on the other side, all of them, mother side, are now Jewish types. And they're only got tiny little Jewish cemeteries in Mississippi, Alabama. We have some more.
Really?
As good as she does, Jewish cemeteries. Very tiny, very tiny place. Absolutely.
It really is. I've had many professors, lawyers who take care of our
I got evidence. That was
my next question. Did you get an evidence?
I got 2 criminal essays. So 3 out of 5 I felt really good on. Our performance test was writing motion for new trial on a homicide conviction. I went, okay, all right, I'm feeling good about that. So, those NPREs are not a joke. I mean, the NDEs.
The NDEs are challenging. They still are to this day. I mean, if I was to take the bar today, I have no problem with the essays. The NPREs, I'm so slow. It's unbelievable.
There was one essay that I just didn't secure transactions. Yeah. Oh, okay. Clearly, I'm not the only one that didn't go. And on the NDEs in the morning, just like, man, I feel like I'm between 2 here on a lot. I didn't feel good. A lot of people didn't feel good in the morning. And then in the afternoon, I feel really good. In the afternoon, I would say about half of them felt like, I know this answer. Okay.
That's actually pretty good.
So maybe I evened out okay.
Oh, that's actually really good. The average person comes out of the MBs usually thinks they knew about 25.
Yeah.
So if you can keep 50, it's actually not bad.
I felt like I said, at the end of it, I felt good. I was like, okay, this couldn't have broken my way anymore with regards to what we actually got on it. Let's see.
I'm really
Absolutely. You know, I'll whisper it to you if I didn't do good. We're not talking about.
All right.
Re-upping on some caffeine. Where's my drip? What's that?
Where's my drip?
They've not outfitted this place with an espresso machine yet?
It is so funny you said that. I made that request early on. We did have an espresso bar. And no, we still don't. Hopefully not. I think that's
I told AJ, once I get under the public interest student loan forgiveness program, like clean that student loan debt, I'll probably just come back here and work here at a greatly discounted rate and donate an espresso machine.
Okay. Cool. Sounds good to me. I think we need one. I have it here.
Breville at home, I think I don't send me back about 600, but
That's not
probably get paid for itself within a month of, figured my wife and I have 2 drinks a day out of that thing, and that's about $20 worth at Starbucks a day.
Oh, yeah.
Not that we were going to Starbucks that much anyways.
Well, but, friends of mine have taken a jar. And every time they want to go to Starbucks, they pay $4 in the jar. All folks making when they did that. At the end of the year, they have between $500 and $700. Can you believe that? What? And they're like, think about it. Just think about it. You just, every time you don't buy that drink, $5 is amazing.
Well, no.
Really?
They both
I'm with you though, to say, the dean has given his approval. Maybe we should start let's have a fun. Get back to you on that. I like that idea.
I am a trained barista. I went to Starbucks. I didn't want to get lost.
We're gonna make
basically. Next. You have to carry it, you can't drag it.
There's no time to smoke, there's not.
No, because it's already 6:01. Will. Hey.
Just partying with the big kids there for a minute.
Yeah.
You just get at the bottom of the line.
You did not do the key, the performance exam, right?
I didn't do it.
Okay.
But, where is it? What are you talking about? I'm looking through this and I don't know what you're talking about. Oh, okay. This is a performance exam, okay.
Yeah. I think.
Oh, yeah, there it is.
Not me. All right. And let's swap out one set of papers for another. Let's see. And last but not least. Okay. Alright. This is week 2. Alrighty. Well, good evening, everyone. Alright, back to legal revision. cetera, et cetera, et cetera. Okay, so as I recall, oh, I see a nice blue book. Excellent. Okay, so very quickly, just so what we did work out was on Saturdays, the actual staff here, meaning either Kelly or Veronica, will be picking a 90-minute PT for you. There will only be one on Saturday. There seemed to be some confusion about that. The other assignment you will have during the week, I will, after about week 4, I start to give you PTs as well. Okay, but the ones I give you are the old 3-hour ones. And the reason why is because I want you to learn how to write. And so these are actually more conducive to having you write, more like in a law office. But again, you're in your 4th year. So when do we start bar prep? Yesterday. You can't get enough. The more that you just make it, try to set your mind. Law school, whatever prep you're gonna do, bar. Okay, it's all one thing, right? Don't let down until you run through the finish line. Right? It's a big mistake that students make. They get out of law school, yeah, you wanna take a week off, take a week off. I don't care. Go somewhere, do something, that's fine. But get back to it as soon as you can. Again, statistics show us overwhelming that students who take the very first bar they're eligible for, the June bar, after they graduate, are the highest passing students. Okay, the first time takers, that's the #1 statistic of passage. So again, if you want to take your best shot, that's what you want to do. For what it's worth, I don't mean anyone or anything in particular, everyone's different, don't get me wrong, but over the years, that has been my experience, is that students that take 6 months off, or students that do any number of things that they do, right, they don't tend to do as well. They just don't. They get out of the mindset. And believe me, one of the things you will start to see this, maybe not this year, maybe 10 years, but one day, I always tell all my students, keep my email around, So, because those things never close, they just go on even when you're gone. They sort of stay open unless you do something about it. But, just one day you'll say, oh yeah, you're right, it was all one piece, wasn't it? And I still get students over the years who, they usually contact me through Facebook, just so you know. I have an enormous amount of ex-students of mine who still talk to me on Facebook. But again, I actually invite you to do that. It's actually fascinating. They all have these really great careers. And not all of them are lawyers, most of them are, but some of them are not. But they're all very successful, second time learners. Yeah, really, they're doing great. I'd love to hear from them. A couple of you always think of in particular, it's like, I always did something fascinating. I haven't gotten a senator yet. Had a couple run for Congress, believe it or not. And I've always got some running for like city council and stuff like that. It's just, you too, that kind of thing. But anyways, okay, so let's all keep that in mind. So again, can't start practicing for the bar too early. And so this class is sort of gonna assume that as well. Okay, so we're gonna do whatever we can to facilitate that process. And again, you don't have to believe me, it's just common sense. But let me just lay this on you every chance I get. You want to pass the first time. Okay, you really, really, really do. Okay, not passing the first time, I'm not saying people don't do it, and lots of people pass the second, there's plenty. Some of the best lawyers I know passed the second time. One lawyer in particular I'm thinking of failed 5 times. He finally passed the 6th time, and he's a very, very, very good lawyer today. It's like, if I have certain questions about something, I will call him. He's way smarter than me. Passed the first time. What does that tell you? Anyway, so, hey, wait a minute, that's good. Anyway, so, hey, wait a minute. Hold on there. But anyway, so you really don't want to not pass, okay? Because you always risk getting on what I call a hamster wheel. Imagine, failing the bar 10 times. I mean, think about that. That's 5 years, $10,000, fill in the blank, fill in the blank, fill in the blank. And those are just, the hard figures, so to speak. I mean, just think of, taking so many years of your life and denying you the opportunity, some of the higher earning years of your life. You won't be out there doing high earnings. So think about the damage that does, to your economic viability and things like that. I personally, again, it's just, me, but there was no way I wasn't going to pass the first time. There was no way. Whatever it was, I was going to do it. I did it. That's all there was to it. So, for whatever it's worth, and believe me, I've never been considered a very good student. Maybe one day we'll talk about that. But anyways, I almost got thrown out of high school for truancy. That never left me. Anyways, oh, come on, give me a break. I was a Los Angelino going to school in inner city Los Angeles. What would you do? Would you go to school or would you go to the beach? To me, it's a no-brainer. What do you mean I'm going to school? You crazy? What do you do that for? Anyway, yeah. Okay, so anyways, enough of that approach. As I recall, anything else anyone wants to talk to at this point? Or can we move on? Okay, moving on. Good job. Okay, so on Saturday, what we left off with was we went ahead and we did the palindrome recording contract, right? We went ahead and we did that. And we went ahead and gave you an answer sheet. We did a little bit of work on the memo part, right? Which is reading the memorandum, getting the idea of what you need to be very focused on getting an outline. It truly is the key to passing a PT, particularly now when they're only 90 minutes, so you're really going fast. So, remember the PT counts for an essay and a half on the bar now. So it is very, very imperative that you pass this. I've seen a lot of students lately who've gotten pretty good MBA grades, pretty good essay grades, but then think about getting a 50 or a 55 on your PT and having that count for 1.5, of your essays, and that can really drag you down. Because again, you're going to get, what that does is here's one of the things about the bar you have to be very careful of, all right? Is that remember that it's a standardized test with a standardized outcome, right? Have I ever said that to you before? It's a standardized test with a standardized outcome. Therefore, what that means as a practical matter is that you get scaled. If you get scaled up, you're in good shape. If you get scaled down, catastrophe, it can be a catastrophe for you. And I'm looking at these grades and I'm thinking to myself, man, those PTs, they can really pull your grades down. I've seen a lot of students at the MD side just peachy keen fine, and they miss the essay part by that much. And then I look at their PT and I go, if only you'd gotten a 65, they passed. So, again, you can't really, and part of the problem is not so much here, but in the real world, a lot of times they wait to the very last minute. That's been kind of an epidemic problem over the years, is that for whatever reason, and it's partly bar prep's fault as well, is that they wait till the end. Usually in like a couple of weeks, they say, oh, and by the way, learn how to do a PT. And, honestly, again, like what we spoke last week, in my opinion, at least from a scholastic point of view, they're the least difficult part of the bar. I think that's true. I do. Because you're acting more like a clerk. You're acting like you're collecting works and just distilling it down. It's not a whole lot of actual legal analysis involved in that. There's just, picking and choosing and going from A to B and things like that. So if you understand if A equals B and A equals C, then B equals C, you're probably in pretty good shape, okay? You don't really have to go much further than that. It's the students that go further than that that fail. Anyway, starting with that said. But, again, you have to theoretically keep in your mind, you have to pass everything, all right? Never sit there and say, well, I'll do good on this and I'll do not as good on this. That doesn't matter. So you have to pass everything. So what would be better? Okay, let me ask you a theoretical question here, which you're all going to know the answer. What is better? To be average at everything and pass, or be really good at one thing and really bad at the other?
You're really good at one thing and bad at the other.
Cosmetology schools across the street. You have
not artistic enough for that.
I don't know why students do that.
But isn't the bar set up to where you have to pass each part anyways? So even if you fail the PT, you failed even if you did really well?
No,
Or no, because it counts
used to
as
be
an
that
essay.
Yeah, it used to be that way. Now, your essays and your PTs it's only half and half.
Oh, so they're averaged together now?
And the PT is worth 1.5 essays though. Okay, so you've got to pass that half, and then you've got to pass the MBE half.
Mm-hmm.
The MBE half was brought up to 50%. And it used to be slightly under that.
You just have to pass both sides individually.
You must pass both sides, but not the PT part anymore. But I've seen it drag the grades down.
Yeah.
So it sounds like they're doing you a big favor.
Yeah, because somebody told me that like you have to pass each essay. If you fail one essay, you fail the bar. And because they said it's not like because I think it was like one of the first students who took it. They said instead of the baby bar where they averaged them together,
right,
they said they looked at each individual essay, and if you failed one, you failed a bar. And I'm like, that doesn't make sense to me, but
that's actually not true.
that gives me a heart attack.
I mean, you can kind of look at it. I mean, if you don't answer a question
Oh, yeah.
on the bar, then as a mathematical certainty, you're not going to pass, because how they give you 40 points, but how are you going to make up that 30 that you had to find somewhere? You're not. Then you're guessing that on all other essays you're going to get 75s and above. It's not going to happen. It's ridiculous. So where's that money going to come from? You know what I'm saying?
Yeah.
It ain't coming. So that's why you have to be careful on that level. So that I understand. Maybe that's what they meant, is don't take a 40 on one of them.
So like even if you get like a 60, you're basically
That's
done.
not true. I've actually seen.
Okay, so it is still the average, though.
It is the average.
Okay.
Yeah. And I have been told over the years you could probably take 160 as long as your other grades are
Good.
pretty standard, then you're probably okay. But no more than one, okay? And don't plan on taking 60. Again, it's just silly. Just, just become average at everything. How do you become average at everything? Does anybody know? There actually is a way that you can assure yourself being average at everything. It's a little difficult, believe it or not. Harder than you think. Ready for the answer? Whatever you dislike the most, do that first. Whatever you think you're weakest in, hit that. Don't, students, and I'm not saying anything personal about anybody, but I'm really good at criminal law. Okay, and your tort grades are, so stop writing me criminal law questions. I don't care anymore. Write me tort questions. Better that you would get 70s across the board than you would get a 75 and then a 60 or a 55. You know what I'm saying? So one of the tricks when you're doing your bar prep is be totally brutally honest with yourselves and say, what is the last subject I ever want to do? Do that one first. Okay? And just get everything up to a certain level of competency and then move to the next thing and then move to the next thing. If you see yourself getting particularly high grades in one subject, don't do it again. I mean, I know students love it. Everybody does. I would have loved to, except I was bad at everything when I was not a bar. Very first time I took a bar prep mock bar, and again at my school, how many multi-states did we do in 4.5 years? Zero. So the very first one I ever took was at Barbary back in the day. And I took it, and I thought I did pretty well. I said, oh, yeah, I think I did okay. Blah, 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 blah. Grade comes back 20 out of 100. I went, oh my God, I've got 2 months. Or whatever time it was. So you can imagine that. But part of the thing that saved my bacon on that one, although I'm Jewish, so bacon's kind of weird. But nonetheless, especially on the day after Rosh Hashanah, think about all that stuff today anyways. But was that I realized I was, and again, I don't hold it against my school, but I guess I was lucky. I was bad in everything. It didn't make any difference which one I picked first and last. But I knew that everything just had to be up to a 70. I figured that out, And it's just a lot of writing. I mean, that's how I saw it. I mean, not, being facetious. It's just an amazing, to me, it was just a remarkable amount of writing. And that's what it was. Anyway, so that's a very good trap to avoid. Another good trap to avoid, I constantly recommend to students as well, don't guess what's going to be on the test. Again, You all will ask me if you talk to me. You'll say, well, what do you think is going to be on the test? And I'll just say, oh, look at Fleming's list. This is as good as anyone's. But, you know, or go to, what's that other one everyone likes? Bar Secrets. Those guys really like to pull out the crystal ball and figure it out for you. But, you know, don't guess what's going to be in the bar. You know, the best feeling in the world is what? Don't care. Throw it at me. Give it to me. You know, bring it. I don't care what you bring. You know, doesn't matter to me what question it was. You know, doesn't matter at all. So the funny part is when I took the bar, I did the summer of 1999 bar, and later on I found out that it was considered one of the hardest bars they'd given in years. But the weird part is it didn't matter to me because again I was average in everything, and we had like an evil con law question. I look back now and it's like that was an evil con law question. And then we had, oh dear, we had the evil real property easements question, which students, at least in my day, hated real property. They hated, you know, easement questions in particular. I don't know why. To this day, I think they're really easy. That's probably why I teach real property, because they didn't bother me at all. But, you know, again, I had just attained a certain level of mediocrity, which got me through the bar the first time. So, you know, we're not looking for genius, we're looking for passers, right? I tell you truly, if Cardozo took the bar, he would fail miserably, because he would not only try to answer the question, but he'd try to change the law. And believe me, that's the last thing you ever want to do on the bar. You want to argue. On the other hand, but we should hold manufacturers liable. Don't do that. They're not liable now, then so be it. You may never be a Cardozo, but that's okay, you'll be a lawyer instead. Okay, so then again, my advice again, you know, take it for what it's worth. It's a test to have you enter into a profession. Yeah, everyone kind of internalize that. It's a test to have you enter into a profession. You're licensed by the state. Why is it any different than taking a carpenter's test if there is such a thing? Why is there any difference than taking a, you know, whatever you're going to do in your, you know, in your career, you're probably going to take some test somewhere, right? I would probably argue to you there's none more useless than the SAT, but that's me. But you know, chances are you will take other tests in your life. It just so happens you'll never take another one quite like the bar. That I would agree with you as well. So, God wants to say at this point, okay? So again, if you have any questions about the bar, please feel free to ask me. If you have any questions, again, do as much as I can in this class to help you out with anything that I can do now. Now is good, you know, better than later, to be blunt. You know, too late is too late, but we're not going to let that happen. Right? Okay, great. You all can pass. By the way, there's no doubt in my mind. I'm happy to say it on tape. All of you can pass, all right? All of you can pass the first time. I'm telling you. Okay, so don't sit around at home and say, I don't know. You know, I'm telling you, you can all pass the first time. I can tell when people can and they can't. There are sometimes those times when it's not going to happen. It has nothing to do with intelligence, by the way. It's all attitude. I just know some people are going to go to the guillotine. They just are, because they're not going to do what they need to do. You guys will do what you need to do. That's aces in my book. Okay? So let's make sure you do it and stay off that hamster wheel. Yeah. So what's one of the best ways to stay off the hamster wheel? Pass your PT. Okay, pass your PT. In fact, let's get to the point where you consider the PT, you come to my opinion, which is the PT's the easiest part. Why not? Wouldn't that be nice to have a break for an hour and a half? Wouldn't you like to go to the 90-minute PT, finish it in 80 minutes and say, hey, I got 5 more essays to go. I got 10 minutes in the bank. What's wrong with that? I mean, to me, that would be, it's funny because I don't know if that would quite hit any of you or any other students in fourth year quite as much as it hits me. But it's like, man, that'd be sweet. You know, that's 10 minutes I pick up on that. You know, think of all the people there that struggle with those PTs. Man, you're going to wipe them out. You know, now you've turned it into an advantage, right? Rather than, you know, kind of this albatross that people think they have around their neck. You know, to me, the PT is your chance to pick up a couple extra minutes there, you know, and have that for your essays. Because your essays are, you know, for whatever it's worth, you sort of you are recreating a list, you are recreating an organization, you are responsible to know rules, you are, the more goes into it, the more you can forget, the more you can stumble over. But PTs, it's like,
So do they just give you like the packet?
yeah, give me the packet, and here you go. You're gonna get your file. The top will be your memo. Then you get the file. The files are the facts.
What do they give it to you with the essays just at the beginning of the
I don't know if they do anymore. I think they do. Don't they just give you all at once? Yeah, they must, because some students do their PTs first. So they must give it all to you at once. Yeah. So, again, I'm not recommending you do them first. It's really up to you. Every student's different. Although I can tell you that I would do them first. Okay, because I would want to see if I can. And I'd feel good about doing it in 90 minutes. I wouldn't have a problem with that. But I'd like to see if I could pick up a couple minutes on that. I mean, imagine what a confidence booster that would be. I got 10 minutes in the bag. Oh, so sweet, right? And you're not constantly like, sweating on the clock, right? But you will do it anyway, but not as bad, right? So there again, it's all about attitude. It's all about getting a style, getting a method, getting a technique down that allows you to get through the material, all the material, over a 2-day period, right? That's what you have to do. It's just a mindset, knowing that you can do it, right? Knowing that you can do it. That is really the key. If you go in there and you think you're going to design it that day, and then all of a sudden your brain is going to become twice as big, guess what? That doesn't work. Matter of fact, I recommend highly against that in life, because in fact what will happen is you'll kick in adrenaline, and adrenaline actually clouds your thoughts. Not a good idea. It promotes action, makes you want to get up and beat up the proctor, but that doesn't help much. So going to the last minute, and none of you will. I'm not worried about you guys, but
Don't argue about that.
it just don't. Just learn this.
I handed them over.
I know.
Yes, sir, I'd like another. Whatever they give you, that's it. You like a hit in the head? Yes, sir, I'd like another. Okay, that's your day to be what?
sheet?
Eat sheep. Just sit down. You'll have someone here and you'll have someone here. Forget about them. Okay? Get into your own little world. Go through it and be done with it. Okay? Be done with it. That's going to be my mantra for this year with you and a couple other people. Just be done with it. Okay? All right. Okay, let's move forward. So you took a stab at palindrome. What do you think? Anyone have any comments? Anything they'd like to discuss at this time? You now have this is a 90-minute PT. Again, I don't expect you to be able to do these in a timely fashion yet. You might be able to. I don't think I could the first time I did a PT. You know how long it took me to do a PT the first time, by the way? And I actually saw one of those. My very first PT I did, if you're ready for this, it was 7 hours.
What?
It took me 7 hours. I've never seen one before. And they gave us a practice one, and what they did was they told us to finish it. Note where you're at 3 hours, but finish it. And when I was finally done, it took me 7 hours. Can you believe that? To actually finish it. And guess what? It was all wrong. I would have failed anyways. So I spent 7 hours in abject failure. But I learned a really great lesson, which is give them what they want, and you can do it in 3 hours. Because after they showed me what really mattered, I said, oh, I can do that in 3 hours. So what did I do? I turned my brain off, stopped trying to answer the question, and just turned it into really just the exercise that it is. And then all of a sudden, something clicked. And all of a sudden, there were just really no problems. The next one, I think I took like 5 hours, but it was pretty good. And then again, what got me to 3 hours? One thing got me to 3 hours. What was it? Practice. I just practiced it. Like I was so sick of them that I just naturally, if your mind gets bored, one of the things it'll do is it'll make you go faster to challenge yourself so you won't be as bored. The mind's kind of a wonderful thing that way. So it'll like try to get you interested. It'll try to get you, to move forward and challenge yourself. Yeah. And so mine did. And, by the end of the time, it's like, again, what I recommend you do, and you'll see this, honest to God, no problem. Finish all the PTs you're assigned, no matter how long they take, but at an hour, at 3 hours, just draw like a red line wherever you were. That's the part you already have down. Okay, you got that. That's not the problem. The problem is going after it. But you know what the best feeling one of the best feelings in the world is, though? When you watch it go. And that's what'll happen. You won't go from here to here. You'll go. And all of a sudden you realize, oh, yeah, he's right. It just doesn't happen in one day. It's just you just keep practicing. And all of a sudden all this stuff becomes like second nature. You're making less decisions, which saves an enormous amount of time. And think about it. Sometimes it's remarkable when you know what you're going to do before you even do it, how much time that saves. Again, indecision is not your friend. Right? Going forward is. Just moving forward, never stopping. It's kind of a weird theory. We'll get into it later. But really, the best thing is to never stop. Okay, just keep going. And I know that students hate that when I say that, but it's true. Your better bet is just never stop, keep going, never look back. That's the person that's going to pass. The person that sits there and goes, I don't know, and goes backwards and forwards, and then does this, and then goes back over their MVEs and changes 9 answers. Okay, you had 8 right, now you have 1 right. Very common. Okay, so it's all about process. Process, right? All right. So we took a peek at this one, palindrome. Again, palindrome is a question that's near and dear to my heart because I actually signed a contract like this once. Although again, mine was 127 pages long. At the time, of course, I had absolutely positively no idea what it said. My attorney said, sign it. I said, good. He said, $1,100. I said, great.
Were you in a band? Were you in a band?
Yes, I was. And it was on Island Records, if you remember Island, which since they're sold. They technically still exist. They're famous for finding Bob Martin. I were the one who put them out first, and you too, actually, appeared first. They're 2 funny things. They're my band, which you've never heard of. One and out. All right. One lousy record now, we were. But anyways, but I digress. But again, I warned you. I digress a lot in this class. So anyways, but we got a peek and we looked at the memo, right? Mm-hmm. And in fact, again, I asked you to kind of look at it again. So what do you think? I mean, when you look at the memo, right? I mean, again, if you're going to go ahead and you're going to distill all of this, what really matters is that you need to have some kind of a roadmap, right? I mean, otherwise, how can you do this in 90 minutes? I mean, think about that for a minute, okay? How could you do this in 90 minutes if you don't have a roadmap? How? I mean, do you think you're just going to write it? I don't know the word for that. If you think you're just going to write it, that would amaze me to no end. But if I had a roadmap, if I had an outline, if I had just a very simple, logical, click-clack way of doing things, right? Then it becomes easy because then it's just taking the raw data, right, and putting it where it goes. And if you get stuck, what do? Keep going. And what's your structure? If you just, for some reason, I can't think of anything under the sun. What am I going to do? I'm going to IRAC, and I'll probably pass anyway. Did you hear that? I'll probably pass anyway. So that's your goal, is to make sure that you have that. Because to not have it would mean that basically you would be looking at a painting and you would say, I see the Mona Lisa. And you just paint it? You think that would happen? No, of course not. Sketched it, and the whole thing. It's just common sense. So on a PT, if I gave you all day to do a PT, would you get 90, 100? Of course. He's saying the only problem you have is you really only have 90 minutes. And so that's what puts the pressure on. Because you can't make a lot of decisions, and certainly you can't make a mistake. You really can't make a mistake on PT of that level, okay? It's gotta be somewhere in the ballpark somewhere, right? Otherwise, you're gonna be in trouble. Okay, so but it's like that for the whole bar, it's like for any test. So that's what you wanna do, okay? All right. I gave you a model answer, right? Everyone got one of those? Okay, good. Again, it was your first one, so we're not get too excited about it. Anything else anyone wants to mention about it? Otherwise, again, you'll be given another one on Saturday.
I just think I made it a lot more difficult than what it does.
No doubt.
Because I read this model answer and
So much simpler.
it's basic.
When in doubt, what do you do?
Be basic.
Be basic, and what do you do if you get stuck? Take a chunk and throw it out. Just spit it back at them. It works really well.
And they set it up.
These are the bees.
They set it up weird too, because I mean, at least with all the essays to date, you get 2 calls of the question. It's you do 1, and then you do 2,
Yeah.
and then here it just seems too simple for the bar, and that was my problem with the model answers. It just seems too simple.
So I get
Yes.
I mean, I know that's how they get you, but it just.
Yes. That's good. Excellent. I mean, really, your PTs really aren't that hard. And hopefully cross your fingers. Of course, again, if you don't, so what? But what happens when you get one about contracts or torts? Oh my God. Offer acceptance consider. Oh, it doesn't have consideration. It really is that simple. It really is. Well, in this question, they lack consideration. Okay, is it a contract? No. Move on. I mean, they almost are on that basic level. Because again, they're not super interested in your legal knowledge. In fact, I've noticed that they do have a habit. It's been a trend to me. They'll actually ask you things you don't learn in law school. Do you learn how to write recording contracts in law school? Do you learn how to do copyrights? Well, we do a little bit here. But the one came out not too long ago about copyrights. Another one came out about labor law, which you never learn in law school. But in fact, does it matter whether you even know the subject? The matter is, if you don't know the subject, it even helps because you won't make stuff up. You just get it where you need it. And students do fine. They do just fine with those. Like I argue they do better. Sometimes when you get a tort or a contract question and you go, oh, I know that. It's like, And why don't you know that though?
It's not in your library.
Right? It's a closed universe. If they wrote in your library and it said only people with the names begin with the letter S can actually sign a contract, guess what? Find someone with an S who can only sign a contract. And you'll say, but that's not the law. And I'll say,
Oh, well,
or even better,
doesn't matter.
close. But my favorite is, who cares? Right? I also really like Pound Sand. We'll use that one later at some point, right? And those are very good ones to play with too. I like all those legal terms. Yes, I do.
And this one I had a contracts question, like, is an option have to be between both parties, or is it just record legal points? Or
Well, the actual answer to your question is everything goes to the level. Right? It's like, you sit there and you read it and you actually figure it out and you say to yourself, so if I sign this, basically I can never make 5 cents, right? And they're like, it's pretty legal. Okay, it's the rule in recording contracts to make sure you get a big advance. That's all you're ever gonna see. Anyway, anyone a musician? Okay, never mind. pretty easier world out there to say the least. Anyway, so all right, so we'll keep doing that. Again, I don't want to overload you early on. I just want you to get used to it. Again, do not be terribly time conscious right now. It's not necessary. You're putting extra stress on yourself, right? Learn how to write the correct answer first. See what it looks like. See what it feels like. Once you get to there, just practice it like hell, and you'll get faster. That's how you pass a PT, all right? All PTs, doesn't matter. We're going to get to that point where it does not matter, right? Whatever they throw at you does not matter. You're going to do a good job, all right? All right. So let's go ahead and keep up with that. Okay, thank you. Okay, and let's see what we got. Running a little bit. Oh, I'm just starting. Okay, so today we have something that it actually is pretty important, believe it or not. And again, if you have any questions, today really is the day to ask me whatever you need to ask me. Because I can tell you that when you're a lawyer, regardless of what kind of law you do, pretty much, you have to know how to do legal research, obviously. And in fact, if you're going to do legal research, what do you have to know? Citations. You must know these things. These are like not optional. Okay, these are not optional. Period. They're not optional. Okay, these are things that, again, when you go into court, what you think, when you go into court, what you think does not matter. Okay, have all of you kind of caught on to that already? Being here for now in your 4th year. When you go into the court, what you think does not matter. We know what you think. You think your client should win because that's your job. Got it? So we don't care what you think. We know that's what you think. But what's the problem with being a lawyer? If you look at it that way. And it does, I guess it does bug some lawyers. It never bothered me in particular. But is you never really get to make the ultimate decisions. Is that so? Never. There's only really 3 people that make ultimate decisions under the law, or 2 persons and then a group, so to speak. Who are the persons that actually make decisions that matter under the law?
Judges.
Judges, juries, and think.
Justices.
No.
Under the, you mean your client?
Yes.
Oh,
Client. Yes.
It can't be too complicated. Okay.
Yes, client. Very good. Like, you do understand you can't accept the sacrifice on their behalf. That's malpractice. Other than that. But yeah, those are the only people that actually make decisions. Do they always make good ones? Doesn't matter though, right? Because your job is to what? Persuade. That's what you're there to do. You're there to persuade people that your guy's the right guy. That's what you're there to do. But we all know that, going in. I know that here's the prosecution, here's the defense, right? I know where you think the guy should end up. I know where you think the guy should end up, right? Not a big decision, but lawyers, again, we don't make those final decisions. So what do? Well, any number of things, but particularly when it comes to the law, though, what we want to do is, most of the decision making during the process is, although some are, left to the jury as a matter of evidence, but the judge will decide most of the issues that go along with the trial and things of that nature. And of course, if you have a bench trial, they'll be basically the jury as well. So how do you, I just out of curiosity, I'm just interested in what your answers would be. How do you deal with a judge? How do you deal with a judge? A good judge, a bad judge, an indifferent judge? What's your job? What do you want to do with a judge?
Kiss their ass and pretend and act like you're reminding them of what they already know instead of trying to tell them that you're right.
Okay, that's not bad. Actually, that's pretty close. Anyone else have anything?
It's a really good record for winning with people.
Okay, well, fair enough. For what it's worth, judges, if you're always, you're in a court, so I don't tell you guys, I don't think I do, but always be tactful, just like you would be anywhere. It's not different because you're in a courthouse. Treat people in a courthouse like you would outside and things like that. I don't know, some lawyers, they think it's time for hysterics and they think they love the grandstand. And I don't know why judges, they yell at judges. I think it's crazy. I think you're already wrong. Even if you're right, why are you yelling at a judge? That makes no sense to me. They're not going to change their mind. I'm pretty sure just because you raise your voice. That raising your voice and yelling over people doesn't make you right.
Makes you louder.
Yeah, it makes you louder. But other than that, So, but the thing is what you want to do with a judge is, you want to understand the nature of the role of judges, right? And so when you're in a trial court, in particular, what's the name of the game? What's the one weapon that you have that you can use, that you must use, in fact, to your advantage whenever possible, and must dismiss the possibility if, in fact, it's not in your wheelhouse, so to speak, on your client's side. I mean, what are you really trying to convince a judge of? You're really very close, by the way.
The law.
Okay, but how do you do that?
You're trying to convince them that you're right.
But how do you do, well, not you're right, then they're going to be right. But how do they do that? How do you convince a judge that by ruling for your side, they will be right?
You convince them that they came up with the decision themselves.
But there's something that's even better.
No.
Even better.
I think you spoon feed them the facts of the law
Yeah.
and and then you say the conclusion. I mean, I don't think it.
Just break it down as basic as you can.
Yeah, yeah.
Don't give them room to.
Yes, that way they don't have to. You don't want them to think too hard when they're writing their opinion. You want to write it for them and say this is your answer.
Pretty good.
You know what I mean? Like that's your goal, I think.
Okay, good. So make their life easy.
Yeah.
Okay, that's a very good start, everybody. But how about if you're a trial judge, what do you not want to see? What do you think was like something that, they don't get up in the morning, avoid this, like, the plague, but what would you like not want to have happen to you?
Huge holes in research and facts that I have to go on my own and fill in.
Well, that's true. That's a good one. That's one. But what else don't you want to see? Once you have ruled on this case, what's the last thing you ever want to see?
Appeal.
Yeah, appeal. I never see the case again. So how do you convince a judge, I've got a great way to keep you out of ever seeing this on appeal? Well, it's this thing called precedent.
It was like give them good case law.
Congratulations, you will make a perfect one. All you have to do is say, Your Honor, those great minds that have come before you, this is your chance to join the party. This is the precedent. My case is just like this. Person over here will argue it's different. Don't be fooled. If you go down this reasoned line, this venerable line, I used to love to use the word venerable, this venerable line of cases starting in 1891. Right? You will merely be carrying out your obligations under the law to follow those who came before you and not to reinvent the wheel. Should you reinvent the wheel and decide there's a law that's not there, guess what? You might see me again. Do you ever want to see me again? Oh. Oh. And so that's what you're doing. Now that I've said that, how important is research and precedent? How important is citation? How important fill in the blank? It's insanely important, you see? The person, I can't promise you're always going to win, but the attorney that comes up with the better case law is way ahead of the attorney that has no good case law or just has missed the point or whatever have you. It's so key. I can't begin to tell you. And I'm speaking a little bit more about civil law when you're writing stuff down. But even in criminal law, where you're saying more in court, you better know your stuff. You better know the cases that came before you. I mean, otherwise, I don't understand. How could you win? It's even more difficult, I think, in some ways. But I remember one time having a case, just to sort of illustrate my point, which was, and there's many different ways to do this, but I was writing a motion for summary judgment, believe it or not, and I had a winner. I had a total winner. It was I can't tell you too much about it, but it was an employment case, and the company really did the guy wrong. Okay, they did something you just can't do. Okay, you really can't, right? And I knew it. I said, oh, they can't do that. They cannot do that. And there's a gajillion cases, right, that say you can't do that in California. So here I am lining it up and going, oh, this is so fabulous, fabulous, fabulous. And I got this great line of cases going. What was that word again? Oh, the venerable case of, it started in like 1900 something crazy, which you don't usually do. Usually you don't want to do that. But this was such a decided line that I figured, but that else is a motion for summary judgment. I'm just going to Why are you going to change the law that was settled in 1905? I mean, isn't that crazy? Sure, that's crazy. Anyway, so I wrote this MSJ and sent it over, and the other side had to reply. And so here I was, I wrote my thing. I had California Supreme Court cases, I had California appellate cases, all sorts of great California law, because it's California court, California trial. And I got back the opposition papers, right? Opposition papers. And when you saw, you have your list of tables, right? And when you saw mine, it was California, Federal California, District California, Federal California. This guy sends it back, right? And I saw his case line, and it was like Wisconsin, Kansas.
Sometimes you have to.
Texas, and then somewhere in there, I mean, huge list, right, for motions for summary judgment, and 2 cases were from California, and they were both like, I just looked them up and I said, it's funny. Anyway, so what do you think I wrote back in my opposition, reply to his opposition?
These are not binding authorities on this court because they're not from this jurisdiction.
Pretty close, although I was snippy, which I don't usually do, by the way, and don't recommend you do. But I did write back, as interested as I am in opposing counsel's papers, does he wish he was in Kansas? Because he ain't in California. And so, of course, he wrote back and asked me what to do. And so, but that's, little jab there. Anyways, bottom line story, who won?
You.
Killed. Just killed him. I mean, again, you don't usually get an MSJ that's that clear cut. But this was one where really the company did something. It's just like, you absolutely can't do that. I knew it flat out. And so that's the whole thing is, again, my tone was always, Your Honor, we're in California. Everyone's come before you in California, thinks this is fabulous. By suggesting outside sources, which are secondary, which you said they're not binding, right? Not binding sources. The bottom line is he's asking you to adopt law that we don't follow. Therefore, yes, it would be wonderful if we were in Kansas. He might actually win. It's too bad we're in California, and he must lose. Why must he lose? Because you must, and you'll figure out a way to say this. You must rule in my client's favor, merely because I'm doing nothing but asking you to follow precedent. If you follow precedent, right? Now, keep this in the back of your mind. I'm binding you to precedent. But think of it this way. No appeal. I hear they have a golf opening on the tee tomorrow at 1:30. What would you rather be doing? Talking to me again? Without, and it was a very particular issue, by the way. It was how to keep a case out of workers' comp. So I don't think it's the one you want to read at night unless you want to fall asleep. It was actually an MSJ about one word. Can you believe that? One word we were arguing about. But the word was on my side, and I knew it. Strange but true. The whole thing turned on one word in a statute, and how it was interpreted. Really remarkable. Anyways, but you'll get a case like that someday. You'll say, wow, I actually know the answer. How about that? But anyways, you see how I bind his or her hands, make it easy, follow the law. That's all you have to do, and everyone's happy. Otherwise, you can try to make the law, but what are you doing? What are you doing if you do that? You're buying an appeal. That's how appeals happen, particularly when trial lawyers go out and say, well, I think it should be that way. Ooh. That's bad. You're setting yourself up for an appeal, because why? It's not the law, We all know about the importance of statutes versus case law, right? I mean, theoretically, which is more important? Theoretically, anyways, at least.
Theoretically, the statute, but since the case law interprets the statute,
Right.
it ends up being the case law in practice.
Right, and should case law really even make new law? They do sometimes.
They do.
They do all
They're not
right things.
supposed
Not in theory.
They're not
It
really
should apply
supposed
the statute.
They're supposed to
They
apply
should
the
just
statute.
overrule the statute and
And if
have
you
them
overrule
rewrite
the
it.
statute, what are you doing, by the way?
you're getting rid of it.
Hmm?
You're getting rid of it.
Yeah, but what do you think about what you're doing when you do that, though? I mean, think the con law for a little bit. What are you doing, even in a state? When a justice says to the legislature, "We don't think that's what you meant," Who are you to tell them? You know what I'm saying? You're telling me, I don't think the legislature really meant what they said. I think it's in black and white, Your Honor. I think they could have used any word they wanted to. You know, and again, I'm being a little facetious. There are these times when times change ahead. It's like, you know, maybe the judges are right. Maybe it is time for a change. You know, we've certainly had some amazing, you know, case law, and certainly that is a way that sometimes society moves forward, law moves forward. But would that be the exception or the rule?
Should be the exception.
It's the absolute exception. Yeah, it's very rare when that happens, actually. I mean, that's why it kind of freaks me out when they say, oh, in the Supreme Court, they shouldn't make law. They don't really make law that often. You know, I mean, the courts hear, like, Supreme Court heard like 66 cases last year. It's not like they hear hundreds still, things like that. Anyways, but the thing is that's what you want to do, though. That's what the smart, the savvy lawyer does, right? Because again, you don't make the decision. You don't. You make decisions of strategy. That's it. The bottom line is again, keep in mind who the final audience is. In the case of using precedent and things like that, of course, it's really the judge. Juries don't care, right? Do you think your client cares? Have you all, some of you work in law offices and stuff like that, right? Has your client ever called you up and said, man, you found the greatest case I've ever seen in my life? Okay, I practiced for 18 years. I never had anyone say that to me. Not once. What did they always say to me?
Did I win?
Did I win? And
How much do I get?
what do I get? And number 3,
Do I owe you anything?
I wish.
Do I owe them anything?
Why is your bill so high? Would have been my number 3. Do you think I could give you a discount? Well, you just won. What would you? Yeah, whatever, but you know what I'm saying. And so what you have to do is you have to become, see, that's why usually when you start your legal careers, whatever that means, you really want to start becoming a really good researcher, because that's the thing that'll help you later on. That's the thing that'll stay with you. That's the thing that, you know, it will help you through your entire career, okay? Plus, the more you practice, the better writer you get to be, you know? And you'll start to see it, you really will, when you start to practice law. There's a huge, again, students, excuse me, lawyers make, you know, they don't make perfect papers for the, you know, for those of you that watch Judge Klotchko, right? I mean, they don't all write perfect papers and things like, particularly even at the appellate level, they don't write all perfect papers. But the thing is you get these, you know, but I've seen some papers you can't believe that these people have a law license. You just can't. I mean, they're incoherent. And I'm reading these papers and I'm going, I don't even know what he's talking about. I mean, honestly, I don't even know what he's talking about. They just go off on these crazy tangents, and it's just like, what does that got to do to anything? And I remember I actually had to write back to one lawyer, and I said, I need you to define the term ripoff as a legal term for me, because you've used it about 462 times in your papers, and I still don't know what the hell you're referring to and why I should care. You know, Your Honor, you should rule for my plaintiff because this is a ripoff. That's literally what he said. Really? You know, would you like to try some law? Crazy stuff you get from the other side, just crazy, crazy, crazy. And lots of mistakes and things were, you know, the whole thing. And so, you know, honestly, what do you think the judge thought? That's really leaves a bad impression with them, you know, from word go. You know, it's funny, you know, we're giving lessons to in English in the first year now. You may have heard that rumor. It's absolutely true. But on the other hand, I don't think it's a horrible idea. I really don't, you know. I really don't.
I use some basic grammar in that first year.
That would help because I didn't have an English class for like 6 years.
I mean, English? You know, one of the things about, you know, I hate to say it, but becoming, you know, a professor and even a dean, is I really do have to know the difference in where the apostrophe S goes. You know, I've got to actually get that right now. Didn't used to for many, many years. But, you know, now that I'm in this world, I certainly do. You know, students are students. All three mean something different. You gotta know where that little apostrophe goes. So, anyways, Not that it would burn down the house if I did it wrong. But these are things you start to notice and things of that nature. And so, again, it all kind of plays together, but, good writing starts with good research when you're doing legal papers as well and things of that nature. I mean, the two really play together. And so it's important that we come up with a way, and you'll do it for yourself, things of that nature. But you'll come up with a way of, dividing what case law you need and what you should use. And, if you keep practicing the same law, guess what? You're going to start using the same cases over and over again. But you do have to know what they're good for, what they're bad for. You do have to keep up with the law. That's why it's really important. You don't want to get blindsided by a new case that came out. That's bad, right? When someone else has a newer case than you do, that's bad. You never want that to happen to you. We'll talk more about that, but you never want someone to have a newer case than you. That's basically tells you that your case is not so hot anymore, and that's very bad. But with that said, you will come up with a method of doing it. I mean, modernly, more online and things of that nature. But remember that your papers are allowed to be persuasive. Okay. Now, we use different tones for different things, but for the most part, motions are somewhat persuasive. Motions for summary judgment particularly have to be somewhat persuasive. And so there's lots of stuff that you can do rather than just say, well, there's this case and this case, Your Honor, which is good if you're right. I mean, sometimes you've got such a slam dunk, you're like, yeah, don't cross the double yellow line, idiot. How do I write that in cases? This case, done. But, sometimes imagine that you've got a case, and this is kind of why I brought it up, where everything turns on the interpretation of one word in the statute. If I'm right, my client goes in the trial and gets a whole bunch of stuff heard. If I'm wrong, he goes into workers' comp and gets what? A couple $1,000 and we're done. So it was a huge difference. And here it is, all turning on one word. I kid you not, one word. And it all had to do with a spine x-ray, if you can imagine this.
What was the word?
I don't remember. I'm going to have to look it up one of these days. I think I saw the paperwork somewhere. But it was about, an x-ray and about, so crazy. It was just one crazy word. And that's the word we were arguing about. And there isn't exactly a whole lot of case law that's exactly on point on that word, except strangely in California, there really was, because all the case law said, you just read it, you go, okay, their argument's ridiculous. It couldn't possibly be that. It's too restrictive. My view of it was much broader and wider. It made a lot more sense anyways. But the thing is, okay, so you have the good cases. But how impressive do you think it would be, even though, short version is there's two types of precedent, right? Two types of authority. What are those called? Primary and secondary, right? Why is primary primary? Because it's binding. Why is secondary secondary? Because it's not. But how impressive is it when you throw in something from a learned treatise, or you throw in something from a Witkin, or you throw in something that, to help you understand, it's not binding, but to help you understand, one of the greatest legal minds of our time, boom, right, says it's this. How helpful do you think that is? He says, first of all, you're right, which is good. But second of all, do you think the judge thinks you went the extra mile in? Oh yeah, absolutely. Then you get a list of cases from Kansas. Come on, just think about it. Not that in and of itself is going to win the day, but even though it can be somewhat time-consuming, I'm not going to lie to you, I would always try to throw in some secondary source somewhere, just to show that I knew what they were, knew what they were useful for. Now, of course, again, with a secondary source, you want to be very clear that it's a secondary source. This is just to help you understand why you need to follow this case. You need to understand why to follow this case. It's very impressive, right? Certain books that, if you practice a certain type of law, you will refer to over and over and over. Copyrights is a book called Nimmer on copyrights. You constantly refer to it. Witkin, you've heard of him, right? He sort of wrote this big book about everything. We've heard of Witkin, things of that nature. And whatever area you're in, there's always a couple of like Bible books that everyone uses. They're there, use them, throw it in. That's my advice. So again, it's a really kind of a big, it's much more than it may think at first. And again, as an attorney, in my mind, that's your job. Okay, your job is to convince the trier of fact, be it judge or jury, however chance you have to do that, that by merely following what has come before them for any number of reasons, by just merely rubber stamping it and sending it on, that's what you need to do. On the other hand, if you have a losing case and you have to argue why the law should change, of course you have to do that too. You can do that. You can actually say, I think you should change the law. I don't know how many of them will, although occasionally they do, in some courts usually, but nonetheless, you can do that as well, and you can point to all sorts of stuff. They say that the greatest accomplishment a lawyer can have is having their dissent become law. I actually know a lawyer that happened to him. And he actually wrote a dissent in a fairly famous copyright case, and that dissent became the law. All of a sudden, the Supreme Court kind of said, "Hey, wait a minute, he's right." And his dissent, because if you look at it today, the law actually reflects his dissent, and not the actual decision that he was involved in 1960. Actually, it's the 1960 case that he lost. Today, you would win if you went with his logic. So I actually did know a lawyer that did that. What this really, the dissent's kind of remarkable too, to be honest with you. It's like, that's really good. Anyways, but yeah, very cool guy. I actually spoke to him a couple times before he passed away. But he's a little older by the time I met him. Yeah. Anyway, so all right. So let's go ahead and try to. Let's see what time we got. Okay, right on time again. Sweet. Okay, so here we go. We have a couple of handouts today. Okay, and let's just go over and make sure everybody has. And then of course you have a statute. So you had an assignment to do, right? Everyone got that as well. Okay, great. Copy of that. All right. So let's go ahead and perfect. All right. So first off, let's go ahead and look at this one called legal research tips. Let's just go over this really quickly. Okay. And legal research is really important. So do we all have a pretty good idea of what primary and secondary is? Mm-hmm. Right? Did we already have an idea before we came in this class? Please tell me yes. Okay. Phew. That made me very nervous. We did not. Okay. Again, the biggest difference between the two is that a primary source is binding. Secondary is not. Right? Many different sources. We consider all day naming them, I'm sure. Secondary sources. My favorite was usually some kind of law review article, because I always thought it looked really good. Just to put a law review article. Although again, during my career, I used Nimmer many times. I used Witkin many times. A whole bunch of different ones. Very interesting. If you want to get really, super involved, you can actually quote legislature. Say what? Looked up the legislature notes and look what they said. Very interesting. And as long as you're truthful, correct, you're fine, right? No problem. You're allowed to do that. You're allowed to do things like that. And so again, to me, the better paper has at least, and you won't do this, trust me, but usually it has some secondary source anywhere. And again, I know that it can be very time consuming to find something, but at least the first time. But it's very impressive. I'm telling you truly. I was always really personally impressed whenever I get something back from an opposing attorney, because it's kind of rare, to be honest with you. And they'd actually talk about a secondary source, But I always thought that was really cool. Anyway, so to me, it always shows that you would go the extra yard, that you actually knew what you were talking about, that you weren't just doing one, putting a name word into a search engine and bringing down 10 cases. Good for you. That never really impressed me. I mean, I think just about anyone can do that. Anyways, so we are looking for a list of both. Again, remember that there are some rules. What is actually the supreme law of the land?
The Constitution.
Constitution. So again, not that you usually use the U.S. Constitution, but you might. Might you also have a chance to use the California Constitution? Oh, yeah, for sure. For that, so always start at the top and move to the bottom. I'm not saying you'll use them all the time by any stretch of the imagination. But I'm just saying, remember that you have a lot of weapons in your arsenal that a lot of lawyers just simply don't take advantage of. And they've always been really kind of surprised, So, anyway, whatever that's worth. But then again, I loved to write too. That was my whole thing. I actually would write for other attorneys and ghost write for them constantly, So that was just my thing. So anyways, so keep that in mind. So you do want to have your list going that way. Okay. Secondary sources. Okay, again, give you a little bit of a list here. Treatises are pretty good. Legal periodicals are pretty good. Legal encyclopedias, ALRs, I think we still have those around. Restatements, and then loose leaf services. How many of you work in a law office? How many of you had to start by updating the loose leaf services?
I was at the library.
The library, the little papers come in the mail, and you guys stick them in where they go into a binder that they send you whenever something new comes out. Those are called the loose leaf services. They're actually very useful because when you have a loose leaf service, what never happens to you as long as you read it, you never get hit with the new case at the other side. Remember, whenever you're writing, it's funny because AJ and I were, Professor AJ and I are right on the same point on, there's many things we agree with, but the one we really agree with is that it's foolish to not know what the other side's going to say before they say it. You really have to understand, whenever you have your side, it really behooves you to make an effort to understand what they're going to say. Okay, because you got to anticipate and you got to what? Right? You got to cut that off the past. I used to love writing papers that would say, learned counsel will undoubtedly look to the case of blah, 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 blah. But we know that's not what it means. It's already been tried before. Why are they trying to do it again? Because they have no case. Rule for me, precedent, next in line, 1:30 tea time. Oh yeah, let's go. That's your rule. Okay, that's a good attorney. But don't put the part about tea time. And the only reason I say that is because I really did have a judge before me, and I was in court. I was one of those few guys that actually really, a judge said this. He was looking at us because I have 1:30 tea time. And we both looked at each other like, oh. Well, you learned. Let me help you with your slice. I to this day do not know if he was kidding or not. Honestly, I really don't know. So we weren't there at 1:30. Yeah, okay, so those are all very good to use. Okay, so you want to be able to do that as well. Okay, moving forward. There's two things you have to know about citation. Number one is we're actually going to study a little citation, right? And then the second thing that we're going to look at before, hopefully we'll get to these two before the break, never mind, but we'll do the best we can, is shepherdizing cases as well. Okay, how many of you have shepherdized a case?
On the computer. On the computer.
Oh yeah, that's fine.
Right, click a button that says shepherdise this case.
Yeah, I mean, back in my day, right, you flip through the red books, it was always, and you look up your case and you read the whole thing. Now they don't even make shepherds anymore. I don't know if you guys know that. They only make them on demand, and the only reason they even make them at all is because law schools and sometimes some other institutions have to have a set for some strange reason in print. At least in California you do, although they might do away with that for looking at, might all be online, it's fine. But for right now, theoretically, every law school is supposed to have at least access to a set of shepherds. So we have a law library. So we don't necessarily really have to have one here. I think it's, I can't remember, we used to call it the 10-mile rule, but I think it's if you have an institute within 10 miles, you're pretty okay. But anyways, they make them on demand. They don't even print them anymore because nobody uses the books anymore, except apparently half of the Supreme Court does, because they're the ones that get the final say, by the way, not the state bar. Most people don't know that.
No.
And they're old and they think books rule, and whatever, your decision. As I have often said, there's nothing that the bar can't do to make your situation worse. But anyways, very good. This time it's actually the Supreme Court's fault. I can't blame the bar on this one. I bar in case you're just kidding. All right, so let's take a peek first at how to read legal citation. Okay, again, in California, whenever you're writing your documents, you're required to actually add to them. Do you know that? Everyone's done that? You're supposed to always have two sources. Now let me tell you about, first thing, if nothing else with citations, is first of all, learn how to do them correctly, because you do want to be able to tell someone where to look. Okay, you don't want them to have to look up something that, from scratch would be very difficult. So it's like, it's like domain names. This is where you go. This is where this case resides. I have known not judges and judges' clerks who really will hold it against you if you don't cite correctly. I mean, they'll actually send you back a note and say, well, I went to that site and I didn't see the case. Uh-oh, that means they're really mad. They're not even taking the time to look at the case, and they know it already. So be careful. I'm just telling you, that's one of the things they really don't appreciate. Make sure your cites are correct, at least one of the two.
Michael Kennedy, he said he used to print out all the cases and staple them to his paperwork. Is that something you could do still?
I don't know. I mean, it's really not a horrible idea, to be honest with you. Because that's one thing that'll really, you look very amateur. I mean, that's one thing. If I get a paper back from somebody and it was, the cites were incorrect or something like, I would really just, fall my hands too. I mean, to me, that's like the least you can do is get a cite right. I mean, so that's considered fair, just so you know. At least in my circles, that was like, you got your law degree where? What bar did you pass? The California one, really? I mean, you just couldn't believe it. I mean, that was just considered so, especially if you made more than one mistake too. But anyways, citations are just the address, right, of case law and whatever else have you. Everything virtually has a cite. You can see it in the Blue Book, right? There's virtually nothing you can't look up that doesn't have some cite. And you're supposed to cite correctly, including all the periods, all the spaces are all supposed to be absolutely correct. And again, and what the best thing would be is just to, be able to go ahead and just, in this day and age, just, go ahead and just highlight it and just put it in your browser and it should just come up. That would be, you'll see it on the internet. It's like, oh, there it is. Or you can put it into, this day and age into, what do you guys have LexisNexis here, right?
Mm-hmm.
Lexus here,
Lexis here, and then Westlaw's out there.
everywhere else.
Yeah. And don't ask. Ask me. So don't ask. But, I mean, my brother's a lawyer. He never uses Westlaw. He only uses Lexis. He swears by it. So maybe he knows something we don't, but that I didn't know. But anyway, so which is not unlikely. Anyway, so everything has its own site. The question becomes, how do you write it out? How do you find it, et cetera, et cetera. The Blue Book virtually gives you everything. But even if not, it actually gives you rules from time to time. It's how to cite something, even if you can't find the site. And it'll tell you how to do it. So that's why it's very valuable. Okay. So if you ever do want a Blue Book, people don't use it so much anymore because, online takes a lot out of it. But I used to still use the Blue Book sometimes because again, I would cite a lot of as much secondary as I could. Right. That was just my thing, and not a lot. Trust me, it was never a lot, but very impressive. And so I would always be looking for different stuff that the judge could take a peek at. And so some of the stuff is like, God, I don't know how to cite this. How do I cite Look magazine from 1963? I don't know. I don't think I ever did that, but I'm just saying, you could, things of that nature. But it actually tells you how to generate citation as well, so it's kind of a nice thing. Now, again, it's not, terribly complex. I mean, we know reading legal citation, cases, you've seen all that before, right? No big deal. You know how to do that right now. If not, it does tell you what they say here. I gave you this little article, which I think looks really good. The names of parties, official citation, and again, parallel citations. Notice that part? You're supposed to cite two. You're supposed to cite an original and parallel in California. Right? So again, you have your Cal appellates. That's that official one right there. And then you have your parallel, which is your Cal Reporter series. And then how many of you know there's a thing called a regional? Okay, they're also called regional reporters. The one in California is called Pacific Reporters. We're the Pacific, but there's also East, there's Northwest, there's several different ones that are done by location. And you can also use those as well. Okay.
I'm really bad with like citations. It's something I never learned even last year.
Oh,
So,
let's talk about this. We must know how to use
Well, I know
citations.
Lexus has the.
yeah, I know the license has the, what's the citation for this and stuff like that. So do we use, so I know you said there's the official, and then you said there's the Cal Reporter one.
Right.
Both of them though say Cal Reporters, so how do I know like,
No, the first one is Cal Reports.
oh, Cal Reports.
Yeah, that's actually appellate decisions.
Oh, okay.
And then the Cal Reporter is the Johnny Come Lately. That's just another source.
Okay,
Actually,
right. So do we, in California, do we use like the official one and then the Cal
That's
Reporter
what
as the secondary?
That's what I did.
Okay.
Yeah, but every so often, for whatever reason, I had to use the Pacific every so often because maybe it hadn't come out yet or something like that, or whatever. But you can use the Pacific as well, but that was never that's not the go-to one. Go to the appellate reports first. The Supreme Court, of course, cases at first, but
Mhm.
then you go to the Cal Reporter second, and I would go to the Pacific series third. And so, but those you do, as I recall, you're still supposed to quote two, not one in your paperwork. I don't think that's changed since I wrote documents.
I can never really tell when I read through like motions and stuff that we do at the firm because there's just so many numbers and
Yeah.
and that's the problem that I have is that like when we went over it last year there's so many numbers and it didn't note them.
Well, it's really important. It really is. And again,
No, I know it is. That's the
I'm just saying,
problem.
make sure you get them right. I mean, really, it leaves a bad taste in everyone's mouth if you get it wrong. It's like, oh, come on, how amateur can you be, right? I mean, that's way down there somewhere. That's way down with writing rip-off as a legal term 86 times in a 15-page paper. Would you like to expound on that? I can't find the Supreme Court case that talks about rip-offs, I'm sorry. Excuse me. Anyway, so there you go. Got that going on. California Court of Appeal.
So like
I say Supreme Court, we know that.
I'm looking at the I pulled it up on Lexis, like the Marvin versus Marvin case.
Yeah.
And so they give us like the official reporter and then the national reporter. Is that not right? Like,
I don't know.
can the judge tell you? Okay, oh, the national reporter is the Pacific.
Is it the Pacific Reporter?
Actually, they have all of them.
You can pick a
So
state.
I don't
I was
know.
gonna say they should have all three.
Yeah, they have. It has the 18 Cal 3D and then the 130, but then it has Cal Reporter first,
Some people put Cal Reporter first.
and then the Pacific Reporter second. But they don't give you like the option to put in the California one. So would you just
Oh,
take out the Pacific one if it gives you both, or would you just put all three?
I always just did two
Okay.
because that's what the rules called for. So I was always just follow the rules, don't do anything. Although I did know some people who put in three.
Oh.
To be honest with you, I never did though. I was always I would always just do the appellate report and then the report. Those would be the two that I would think would suffice. But again, the last time I wrote a legal document, to be honest with you, just to give it to you from my experience, was probably, I don't know, 5 years ago now. So I don't think it's changed that much, but I'm just saying whatever, and you can always, I tell you something too, I mean, a lot of lawyers never realize this. Not that it's something that you should make a habit of that to some degree. But the judge's clerk will answer questions for you. Call up and say, how does the judge like his citations? They'll tell you.
Very nice.
Yeah, most of them are pretty nice. When I practiced, they were pretty nice. They would like to, I had several who would keep me on the phone for hours if I let them. I'd say, don't you have anything to do today? So I'd be thinking in the back of my mind. But they give you lots of really good, hints sometimes. I had this one clerk who was saying, oh, he doesn't like that. And he likes it like, doesn't like grinders. He likes this. He doesn't like that. He likes this whole thing. I don't know if I did everything she told me to do. I don't know if it helped. I won. It was an appeals thing. So, but she was super helpful, and you're allowed to do that. What else can I tell you? It's not, sometimes I guess they won't answer you or they won't call you back, I suppose, if you leave a message for them. But more times than not, they were always a really good source of information for me.
Yeah, I have a question about
Just remember
that.
the local rules too.
Probably.
You guys know about local rules?
There's also California specific rules, which are different than the Blue Book.
Yeah,
Oh,
you
they
have to follow
for it?
California.
Well, they're different than what we're even learning here. And so, the public defender's office likes to use the California rules, but it seems like it's all over the place. Who uses what, the Blue Book is permitted anywhere in the country, and then you also may use the specific California style rules, which are different than this right here.
That's true. This is very general.
So, are both generally acceptable? Is that kind of
Use the California rules.
use the
just-
use the California
See,
rules?
what I'm trying to do is I'm trying to get you to do it one time, do it right, and just follow that for the rest of your life. This is just generic.
Okay.
But always use the California rules, always use California style. But remember that, again, there's a couple of different things you have to keep in mind since we're talking about actual practice now. Remember that there's the big rules, right, which you're talking about. And remember there's local rules, right? So you always have to look on the website now for local rules. And you want a big hint when you call the judges clerks. Okay, are there any local rules?
Right, the court rules.
It's very interesting sometimes when you get the answer back. And if you know those types of things, who are you keeping happy?
The judge.
Excellent, right?
And the California Rule of Court says citations to cases and other authorities and all documents filed in the court must be in the style established by either the California Style Manual or the Blue Book, a uniform system of citation, at the option of the party filing the document. The same style must be used consistently throughout the document.
Right, but I would use the California style because most judges are used to it.
Should I order a California style manual?
Yeah, just get the style manual. It's no big deal. So I can't imagine changing that much since I was writing. And those are the two that I would use. I would find whatever it's worth. But remember that though, write that down somewhere. That'll be something you can email me or Facebook me years later. I just asked about the local rules, and you'll never guess what they told me. A couple times it's like, he doesn't like those tabs? Okay. Whatever. I'm good. I would just ask. Good. Okay, so. Okay, so we have all that. All right, we know all about federal law, right? With state and federal. Federal is, good. It's good stuff, right? Different citations for that as well. Again, in California, what circuit are we in?
Ninth.
Circuit. If you're talking about a district court, that will be your supplementals. Right? That can be good. That's no big deal. Again, it helps to know codes as well. Make sure you cite the codes correctly. any code or statutes. You know, again, it looks really bad when you don't, particularly when you get the wrong number. It's really bad. And again, there's all sorts of different citations there as well. Okay. And again, it's very important that you know what level you're dealing with. You know, is it? And you know, people laugh when I say, you know, you need to know if it's out of the Constitution, because people do quote the U.S. Constitution. The one time I was actually in England at court, the Old Bailey, I just stopped in one day because I was there. I never appeared there or anything. Although I have worn the wig, believe it or not. Graham has one and lent it to me. I put it on pictures. Anyways, but I was brilliant anyways. But I was actually sitting in court and I couldn't believe it when they were talking about this case. It was a criminal case and they were talking about habeas corpus. Guess what one of the lawyers quoted?
Constitution.
No, even better. Take a guess.
Declaration of Independence.
I was in England.
Magna Carta.
Well, that's why I was like, maybe not the Constitution, but they're just
Wow.
gonna shove it to him.
He actually said, didn't Magna Carta? And I was like, oh, I just dived on the legal. This is great. And the judge said, okay. I'm like, wow, that's cool. So to say that you don't need to know about these things, that's really not true. I mean, it seemed to me the judge was very impressed with the guy who started with Magna Carta. So, you know, I thought that was pretty cool. Anyways, okay, again, you need to know about all the different types of law reviews, treatises. They all have their own, you know, unique number, whatever number, citation manuals, et cetera, Black's Law Dictionary. Please learn how to quote that correctly. So many lawyers don't know how to do it. You can quote it if you want, but it's even on this page here. Just learn how to do it. I'm just always shocked at how few lawyers need that one. It actually does have a specific style that you quoted in, that you cited in, okay? All right. Other than that, let's see. All right, again, I leave you to your internet. A lot of this is actually
Slightly outdated.
plays out. Well, I mean, this is
It's not outdated, but it's
how you do it today is
Old
very
school.
different than in my school. My high school is very different. Okay, let's go ahead and take our break for 15. Take 15 if you come back more than 20, I get mad.
okay.
So go. That's the goal. And then we'll go out with shepherd eyes, very important. In case you're not believing now. And then we'll just go over your assignment and we'll be done for today. Sound good?
Awesome.
And again, you're keeping your notebooks, right? Keeping your portfolios for me. All right, good job.
Getting started.
Remember, no portfolio. That's virtually the only way you can fail this class. Thanks. Bye, guys. Let's try that.
I'm pretty sure I can do that. I'm sorry, like.
I know, I never like.
No, I wasn't small.
Okay,
It does look like Lexus follows California style manual.
I hope so, yeah.
So like Google Island records and then your name, will I get your band out there? Is that,
Is it really?
I'll try to find it.
I haven't actually heard myself in a long time. Yeah, that's not bad.
Yeah.
Just,
PhDs, they call it. Desert Island Records.
oh, that was the thing I was actually.
So is that you?
That's me.
Is there in your band in there?
Yeah. Are you a music fan? Yeah. You're in either inlet or you're in no luck.
See, it's Savage Republic.
That's me. Records that I did. Like that one. What I used to do.
Nice. How do you carry these around?
No, someone asked me for one and I happen to have a copy.
Nice.
I have to go into my garage boxes and find these now.
Am I getting in trouble for the song? I don't think it's pretty
hard.
It just
I was gonna say,
off,
is it just me or is it?
Just hit that down button a bunch of times so it says it's 76 or something.
But it says off.
Oh, nice.
That's a DVD, by the way.
Yes. Was that a good? It's a younger you in there?
Oh, I'm not actually in it. It's actually, I wrote a new soundtrack for an old film called Battleship. You won't actually see the picture there. Yeah, if you look hard enough, it's fine. And some pictures of me. You'll find pictures of me with hair down my waist. If you look hard enough. Not quite my waist, but no, when I get back. If you look hard enough. It's all black too. Long white street.
It's part of research, right?
Oh, you can find that. You get extra credit for sure. Because we're going back many, many years. So.
Everything is on the internet. Everything.
If it's not there, it's not important.
Exactly. Except for NAFTA. Except for NAFTA.
Well, you better look it up quick. It might not be there soon.
Well, no, it isn't. It's off all the government websites, and that's what pissed me the most off about this assignment. Was I was trying to find the part in NAFTA,
Oh, really?
and it's off the government's websites.
I haven't heard about that. I like this. Even looking at this assignment.
So it's from like a .org website, which I didn't want to use. And then one of my friends has access to the UNLV like database because they go there. So they were able to pull like the official part of it. But it was still like, it's not on the government websites anymore.
Okay. Guess it doesn't exist then.
Just for next year.
It's a couple of months.
They'll be doing the next NAFTA next year.
Yeah, we'll see. Should be interesting.
Also, this was named after a movie in Battleship.
Yeah. Time. So, yeah, 2 minutes. Let's start.
Let's see, just bust it out.
Artificial Drucker, Del Rey, the Sun Kings Battleship. I'm trying to find like a soundtrack of it. Oh, there it is.
What are you looking for?
Yeah, it's really neat. Did I lie?
I'm looking for this soundtrack. It's on Spotify. It just kind of links to my Spotify. Do you get any royalties from this?
Oh, well, not really. Well, sometimes, yeah. I still make about, let me think. I still make about I don't know, somewhere between 2,000 and 4,000 a year in royalties. Even though I haven't written a song. You know,
That's pretty good.
some of the songs are from 1982. That's like the oldest ones I have, and they still put royalties in their songs. Yeah. Ah, much better. That is better. I thought it was just me. Really, that bothered me. Okay, but enough of me. Let's go back to Shepherd. Anyways, yes, that's really me. One day we'll find that everyone finds out in this picture of me. Pretty funny. Actually, you want to look at it today, make go, man, that was crazy back then. And the parts that I remember anyway. Which aren't very many anymore. Most of the time when they do, I still get people call me about interviews. That's the thing that never kills me, how people still find me. You know, it just amazes me. It's like, because I don't advertise at all. It's just, you know, I don't have the web.
I'm sure your address is on the bar website.
Yeah, I mean, you theoretically you can find me if you want to, but it's not that easy. It's not very many, you know, what you would call classical sources. I'm just not around anymore. But people still find me from time to time. They still, you know, track me down and they find me and it's, you know, all this stuff. And I always have to tell them the same thing, which is like, I'd be very happy, you know, to do whatever interview you would like, but remember that it's only limited to what I remember from back then, which I gotta be blunt, it ain't a whole lot most of the time, you know. And people will actually call me up and say, well, you were so-and-so and you did this and you did that. And I'm like, really? How do you know that? Well, you were on camera. Oh, must be true. And I'll sit there and look at them for like 10 minutes going, I don't even know what you're talking about anymore. You know, I don't know. And I said, well, you were there. Oh, that's me.
What's it called?
Battleship Potemkin. Potemkin.
Poten.
You take this part out the video.
Potentin.
Potemkin.
Oh, I guess it is a research class. You can find me, you're doing pretty good.
I did find a picture from 2 years ago, 2006.
Oh, yeah, that was. Every so often they trot me out and make me do something.
That's some kind of a book from 1925, though.
Oh, it's a book too, for sure. Has none of you ever seen Battleship Potemkin? It's one of the most amazing movies ever made.
I'm gonna check
It's
it
made
out.
in 1925 by Sergei Eisenstein, and it's still considered, you know, well, he was the guy who invented the collage style of filmmaking. So when you see people like make all these quick cuts, and things it was him that did that. They didn't do that beforehand, or very little. And he sort of took it to a new art form. The best example of that is Alfred Hitchcock's Psycho scene. If you watch it in the shower, it's like basically the legend is that he watched Eisenstein's Odessa steps, soldiers shooting the Russians hundreds of times before he figured out how to cut it together. So people still use that film, even though it's made in 1925, as like a guide for how to visually arrange your films. And it's an amazing film. It's just shocking how good it is. I mean, it's just every bit as relevant today as it was in 1925. It's remarkable.
This was released in 2007, so it's pretty recent.
Yeah, that's one of my more recent things.
Okay.
My old stuff, if you were to ask me to get copies of it, I'd say, you're gonna have to wait. You have to, like, go on eBay and get it for you. I'm sure I have copies of them much more. Most of the stuff I do, but I'm kind of lucky that way. I have some companies that have actually agreed to archive my stuff, so. Let's check some, 40 pounds, okay. It's not the dinner. Got one the other day for 300 euros. Right.
$3.
No, that's $450.
Oh yeah, euros are less than $1.
Yeah. And I also do have a check from Google for 1 cent, which I framed. So why don't you even send this to me?
Costs more than the stamp.
Gotta balance their books.
Yes, they do.
They pay a penny, but then they write off like 50 cents from the envelope.
So they send you a penny, but
So I framed it. I thought it was a nice thing to do.
the toner, the check stock, the stamp, the envelope.
Well, I always write them the same letter in case you ever have the need to. I said, it would be better if you just sent me a book of stamps. I can use those. Are you sending me a check for a penny? Anyways, that's what they do in this day and age. Anyway, so let's go forward and forget about my Scott meeting. And Shepherdizing, very, very important stuff. How many of you have shepherdized the case? All right, good stuff. Really, this is like, not that everything we talked about today is optional, but this is really not optional. You guys, okay, you must know this before you dip your toe into the, citation realm and stating, writing motions and stuff like that, because this is where you can get really killed. This is where the really good attorneys, this is where they show up, they know all this stuff, and they make sure, this is the make sure section, otherwise you get an enormous amount of problems, okay? Shepherdizing, which again, in this day and age is, what we call shepherdizing, but just to give you the short version, what you'll probably do is whatever system you have, you'll put in a case, right? Or even a word search, whatever y'all do today. You put in a word search and it'll bring up certain cases, etc. Finally, you'll find some cases you like, right? You say, oh yeah, that does sound like a case, right? And so then finally, at some point, you're picking the cases you like, and then you, of course, always shepherdize. And let me give you a hint. If you start a document 3 days early, at the end of it, shepherdize one more time, real quick. Just to make sure. It never happened to me, but I've had attorneys where between starting a document and ending one, another case came out. That never happened to me, but it did happen to a couple of people I know. So who looked better? The one that caught it or the one that didn't? So it's worth it just doing it one last time. Just your major cases even. I mean, I recommend you go through all your cases, but it's up to you. But at least shepherdize your major cases one more time just before it goes out. You never know. Right? Yeah, it never happened to me, but I do know at least 2 attorneys it did happen to. Okay, so, and of course I said, well, did you look at the loose leaves? And they said, what's that? Okay, what law school did you go to again? We didn't have my class. Anyways, but I do know guys it happened to, so there you go. So yeah. But anyway, so this is a really important stuff because here you're going to go ahead and put in a case, and then of course what you'll see, I'm just doing what the West version right now. You should see a little flag, right? Y'all know the flag system. Green, we're good to go, right? Okay, there's nothing you need to go any further. Yellow, we'll get back to yellow in a second. Red, do not use a red flag case for any reason whatsoever. It is an offense that you will be disbarred for. Did you hear that? Never do that. I know stupid lawyers that have done that. They say, well, yeah, I know this one has a red flag, but really they're right. Don't do that. You can get disbarred for doing that. Do not put red flag cases in your work ever. Got it?
That's just negligence.
I've
I
done
don't
it
know what
once,
it is.
but it was changed on other grounds, and I explained exactly why.
Overruled.
But for other grounds.
Fine.
I only did it once, and
I would
I
say
had a
like,
whole paragraph about it.
Like, and again, I don't know anyone who's ever been disbarred for that, but yeah, I wouldn't mess with it. Okay, and again, red. I do know an argument. I'm sure you did make an argument. Said, yeah, but it's a red case, but it looked pretty good. I think don't do that. He didn't get disbarred for it, but I know he got a lot of abuse for it. So don't do that. Anyway, so red. My rule is always just stay away from it. I just would never touch it. Just say no. Just say, and they're always perfect. That's the problem. You look at it, and you go, this is a worming case. Why did they overrule it? And it's like, who cares? Move on. Okay. So green, good to go. Red, I recommend you stay away from them. I can't tell you what the other attorneys, if you quote one, they'll probably put it right back in your face, which is also very unpleasant. So again, I just stay away from them myself. Recommend you do likewise. But the yellow ones are interesting, right? The yellow ones are interesting. Because you're looking at this and all of a sudden you've got this big long list, right, of little letters after it. And so it can be very, interesting. The first thing you do want to do, though, it's funny that Will even brought it up, is, cases have many different rules. You've seen head notes, right? I mean, cases appear in many different categories. And so the very first thing you want to do is if you see a yellow flag is, well, what is the yellow part about? It's never about the entire case. It happened. I guess it could happen, but it's about some part of the case. So the very first thing you want to figure out is what part are they talking about, right? Because if it's a part that has nothing to do with your case, right, it just has something else to do, you can say, well, it's got a yellow flag, but so what? You know, it's like, for my case, it's still on solid ground. This is still good precedent, right? So you always want to make sure that you understand which part of the case is being flagged, okay? Because again, cases are multi-layered. They stand, many different cases stand for many different concepts. Well, so always make sure, don't just look at it and say yellow and then say, oh, I'm not going to use this because I'm lazy. I don't want to read the case and figure out what part was actually the blank that they're discussing. That's really lazy. You're going to get, that'll get you in trouble really quick. Because why? The other side's going to use it and they're going to look at you funny like, oh, why didn't you use it? It was, you know, fill in the blank. You know, so that's actually that's the very first thing you want to do is always, when you see yellow, don't give up. I mean, I know a lot of lawyers get discouraged, but particularly young ones, but just look it up first and see what was yellow, you know, because a lot of it might still be good law, so always do that, all right? Then, moving forward, okay, you know, again, I'm not gonna, you can go ahead and read what it looks like, but really the important part is on this page here under part 3.3, the explanation of abbreviations. So let's go over this so we make sure that we know this, because these are really, really, really important. Again, you're looking at a case, and you've got some kind, you've gone ahead and you've shepherdized, and here you've got this, you know, little printout before you, whatever you're doing, and it says, hey, cases, right? This is great. A means same case affirmed on appeal to a higher level court. You think you want to use that one? Oh yeah, that's gold. I mean, it went top on appeal and it held up. This is great. How about R? Do you want to use that case now that you looked it up and it's been reversed on exactly the point you're trying to use it for? Okay, should I take the big flashing idiot sign from you before you do this? That's bad when you do that, by the way. It's like, yeah, the other guy's going to write back and say, that's no, obviously didn't really read the case. Now here's interesting. Okay, those are pretty easy, right? What you get one that's been modified?
We have to read it.
You have to read it. And you have to figure out
Where it was modified and if it was modified based on what you're trying to use it for.
yeah, well, perhaps if we're lucky, the modification is in our favor. Great, this is good. You know, when the court actually goes out of its way and modifies something and it's in your favor, this is good stuff, right? You're like, oh, wow, I'm flying on this one. They modify it against your favor, not so good. And we might still be able to use it, but we've got to be cognizant of the fact that it has been modified, and we have to make sure that we either, you know, distinguish or analogize to the case. Okay, so it's not impossible to still use it, but this is where we have to make that decision. So okay, again, modifications are can be a little trickier. A and R is pretty easy. Modification, that's great. Okay, B. What do?
Throw it away.
Go away. Just don't bother with it. It's not worth the effort. That's my opinion. Vacated means it's been vacated. Forget it. Now here's another good one though. Criticized. What do you think about that? Criticized. Do you see that C? What are you gonna do?
Probably not use it.
Probably not use it, but are we gonna read it?
Yeah.
Why?
Because they may be criticizing a different part of the case.
Oh, and what else? Just out of curiosity.
The criticized case may have been overruled.
And I can think of one more thing.
I'm out of.
I disagree with the criticism. It's still good law. Isn't it? Is that not so? You criticized it. You didn't overrule it. Is that so? You can still use that case. And I would point out it was criticized, but I would be very kind of like, well, it seems to have been criticized. However, case hasn't been overruled. It's still good law. However, the flip side being, maybe I should stay away from it because maybe this judge thinks the criticism's pretty good and wants to get on the panel. However, if he joins in the criticism and tries to overrule it, 1:30 tea time. So you got to really make your decisions on what you're going to put in front. You know, that's good, bad, indifferent, precedent. You don't have to quote everything. But again, there's ways that you can take a lot of this stuff and use it to your advantage. And just to skip over it, I'm telling you, if you just skip over this stuff, you're asking for it. because the other side will do it, particularly if they're losing. They think they've got a loser, you know. I mean, I would much rather take a criticized case and try to make it palpable in California court than quote Wisconsin. I'm not getting Wisconsin. You know, that's cheese law. I'm not getting that tomorrow. This is California. What do you do in California? It's what kind of law? California law. You see, Wisconsin is about, you know, cheese, and then California would be about what?
The golden law.
Golden law? Okay. Granola law is like some of my other friends used to call it. And tree hugger law. Let's see what else have I been called over the years. Oh, you know, it always makes me laugh because I've had so many lawyers say to me, "Oh, you're in California, like we're in another country." Just like, okay, do it yourself anyway. Okay, so criticize, watch that one. How about distinguished? What do you think about that one?
I mean,
Is another, maybe read it, see if it's been distinguished in your favor or against you, right? Because they're saying they're distinguishing cases, which can be very interesting. Because if the distinction goes in your direction, it's even better. If the distinction goes against you, again, it's kind of like, But again, is distinction overruled? The answer is no. Again, they're just showing you that if I give you a short version of distinguished, it would be like, this case is not like this case, but the answer is still the same. Do you think you could fit it in there if you had to? And the answer is you probably can. You can probably take your case. No two cases are exactly alike, right? So hopefully you might be able to weasel that one around a little bit. Again, kind of use it if it's valuable, maybe it's not. I mean, hopefully it just is on your side. But again, remember, don't just throw these cases away, because if you don't like them, guess what? Somebody else does a lot. So you've got to take these things in consideration, right? The best papers take into the other side's what they're going to say, right? If you can do that, you're way ahead of the game, except waiting to get what? Punch. Come on, what take a punch? You know, never, promise me this, guys, never dodge an issue. Just deal with it, acknowledge it, and move on. You don't acknowledge an issue, you get killed on it, because then they know you're ducking it. Don't do that. It's really, to me, that's really amateur. You know, if there's some issue that you don't like, you make sure you say up front, I don't like this. However, it's here. Let's deal with it the best we can. Okay, do not do that. It's a very bad idea to duck it, because you know, not only are you going to see that, but now it went to the top of their list, right? Because remember, you're responsible to answer all of the charges, all of the facts, whatever you want to call it, depending on what you're doing, not just the ones you like. And if you do that, you're going to get hit over the head, honestly. And the judge is going to catch it. Everyone's going to catch that. You're dodging an issue. That's not, to me, that's not lawyering. That's just, anybody can do that, right? The better lawyers are the ones that, you know, take the hit. Say, no case is ever perfect. What do you want? You know, you're going to have to tell your clients that someday. You know, your case is not perfect, but don't do that, because the next time they show up, it will be. That's a bad sign. You know, let me just warn you real quick, now that I'm saying, oh, clients do this, but it's amazing. Every so often I'd have a client come in and they tell me the case, and I say, well, that's a pretty good case you there, but you're kind of lacking this, this, and this. And they write some notes down. And they say, well, what are you doing? And they say, well, here's a case or whatever, you know, and I'd say, bye, nice knowing you. And miraculously, they call me back and they say, like, well, actually, the way my case went was like this. Duty breach causation debt. Oh, now you've got fill in the blank. No, bye. I know. Don't deal with, I can, nothing personal, but don't deal with people like that. You know, it's bad. You know, again, the funniest, the thing that used to just get me when I was, you know, practicing in the law office and in litigation was just how many prospective clients would walk in and they would say things to me like, well, if you're the attorney to take this case, you must know what the position is under CCC 1221. And I'd always look them back and they'd say, I have no idea what that is. And they say, well, how can you be a lawyer and not know what CCC 1221 is? And I'd always say, do I look like a walking code book? That's why I have a book right here. That's why. And I look it up, and of course, So your facts exactly fit that code, right? Of course. Goodbye. Nice knowing you. And where did they hear that from, by the way? Another attorney that they went to already turned them down. Get smart, okay? Never trust it. Okay, one more promise for today. If a client ever comes in with a perfect case, what do? Kick them out. There's no such thing. It means that, in other words, what they've done is exactly what I said. I can't say that 100%. You may actually have the perfect client walk in someday. But let me put it to you this way, as we say down in Texas, it may rain horrors, but it will. Ain't gonna happen too often, I'll put it to you that way. All right? So again, probably the smartest thing that another attorney ever said to me, I kid you not, I'm not being facetious, is you make your practice by the clients you don't take, not by the ones you take. This is so true. I can't begin to tell you. I'm so glad that guy said that to me. You really don't want to get stuck with any number of clients. When you're practicing law, your biggest disadvantage will be what? Your clients. Just trust me. Sorry, I don't say that often, but just the way it is. Just being honest. But what are we gonna do once we decide to do it, right? We're in for a penny, we're in for a pound, right? If you decide to take a case, get ready to talk to a jury. In a closing argument, you gotta be ready to go to the mat, or you're no attorney, in my opinion, quite frankly. You know, oh, I'll just write a letter for you. You're no attorney. That's just my opinion, but that's just me. Okay. Anyways, how about explain? What do you think about that?
Great, probably help you.
Kind of interesting. It's usually pretty helpful. I mean, explain the case. Usually, yeah, you know, it's a coin flip. You never know what part they're, but once you figure out they're talking about the part you are interested in, right? Always remember to look that up. But once you figure they're into that part, right? Usually the explanation is like, you know, how different is it to cross two yellow lines? You know, not gonna get that many strange things. And so more often than not, I would always look at those, because there's nothing better than taking a judge's own words. You know, saying in this case he explained it. That's pretty gold, right? You know what I'm saying? Again, it's not me, Your Honor. It's your learned, you know, compatriot and on the bench, your colleague, your whatever else have you. This is you guys, you know, you guys up there in the clouds telling us how it rains. It has nothing to do with me. And again, the more you do that, the better off you're going to be. You know, I mean, I'll tell you a big secret. If you're writing documents and the word I appears in it, what are you writing? First of all, it's not you anyways, it's your client. Watch for that. And the second word you always want to watch for is think. Do not write think. Every time you see those words, it's like, there's three words you always watch out for. I think, and what's the third one? You know it already. You probably forgot it from the first year, but it's another word you really don't want to have in your writing, and certainly not in your documents, if at all possible. If. Don't have those words in there because they're not relevant. They're not relevant. First of all, who cares what you're thinking? And secondly, there's 7,000 ifs under the sun. Who cares? Deal with the case you're given, not the case you want. Every time I see if in a paper from a student, I say, this is the case you would want. It's not the case your hands, because you're changing the facts. If this were true, right, that's nice. Is that the facts in your case? No. Right. As my torts professor used to say, if my mother had 4 wheels on the top, she'd be a convertible. Figure it out. It actually is very funny when you sit down and realize it. He also had a dog named Palsgraf. Gotta like the guy who has a dog named Palsgraf. I know one attorney had a dog named Palsgraf, and I knew another one that had a hound called what? Want to guess?
Cardozo.
Close. It was a hound dog, though. Best name for a hound dog I've ever heard. Baxendale. How cool is that? That's very cool. I had to admit, I go, oh, that's so cool. Yeah, a hound dog named Baxendale. Pretty cool stuff. Okay. Followed. How about that?
Good.
Gold. Absolute gold. That gets, you see how we're trying to make a chain? That's a beauty. You just want to get into that chain. You see what I'm saying? You just don't want to rock the boat. You don't want to upset the world. You just want to get into that chain of cases. It's a winner 99% of the time. That's really a big key of your writing skills. I don't care what other attorneys say. I truly believe that. You know, it requires you, of course, to take your personality and your ego out of it. But that's the best way to go, honestly. I kid you not. Overruled.
Yeah.
Move on. How about dissenting? What do you think about that?
Maybe,
Maybe. And should you read the dissent?
if you have to.
Yeah, if you have to, first of all. And also, if you think it might be useful. If the actual case goes against you, can you cite the dissent?
Mm-hmm.
Sure, why not? If you're losing, what do you have to lose? You see what I'm saying? If you're winning, I don't know. You know, why send? Of course, with the dissent, why would you say? But if you're losing, you know. Okay, now, on that thought, by the way, all right, when you think of this, don't just think of I'm winning all the time. Think I'm losing. And then all of a sudden, what do? Oh, right? Maybe I can use some of this, you know, to make a better argument, at least if nothing else. You know, because I can't really, I don't know, how much do you think a client would appreciate you if you wrote back, I got nothing? Speaks for itself. I mean, I have seen documents that literally, why did you build them for this? I mean, I could have written your document in 3 words, I got nothing. That's up to you. You know, again, it's only my belief in such things that can't, you know, I actually, you know, one of the things that used to really amaze me, again, you know, for whatever it's worth, but God, I could never, I'd always say, you know, I would talk to some lawyers and I'd always say, they'd say, well, we're gonna do this, 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 and this. And I'd say, okay, fine, whatever. And invariably what would come out is they say something like some version of, not exactly straight on, although some of them got really close. Well, the retainer's 10,000 and I gotta spend it. Think about that. Think about hanging up the phone. You're sitting in the office looking at this document and saying, I got 10,000 and I have to spend it. Oh, I got nothing. Oh, now I see. Oh, I can't stand attorneys that do that. And you'll get ones that say, come on, we'll all do it. We'll run bills. Yeah. Okay. I'm just saying, you know. I mean, I cannot say that I did not get phone calls that were like that. I was amazed, really. To be honest with you. Okay, so what do you think? Pretty good? Mm-hmm. Is that worth knowing? Yeah. All right, very much worth knowing. And to me, again, I stress this to you kind of, is to me, this is where the real action is. You can get to this level and be able to, you know, really work the cases, you know, into like really, remember, a lot of them don't have to be your main case. They can be very reinforcing and things like that. You know, and imagine all of a sudden you're throwing in all these cool cases and you've got a real good take on it. And somehow through this entire maze and mess, you still feel like you're on top. Throw in a couple of treatises by some eggheads over at Harvard that say, you know, yeah, you're right. I mean, come on. How bad can you be if you're a lawyer that can do that? Pretty good stuff. And it'll be fairly, and you know, as long as you know your stuff, it'll be very compelling. You know, I think, what's more compelling, just sitting there ranting and raving in a paper, or actually, you know, writing something like I just said? Is very compelling. You know, all of a sudden you're really putting a lot of pressure on people. You're putting pressure on the judge. You're putting pressure on the other side. Putting even pressure on your client sometimes. You know, maybe it's time to fold. Everyone's telling us to fold. Why are we still doing this? I don't know exactly your documents are the best place to do that, but you know, telling the truth is, you know, it's kind of a good way to go. You know, you'd be surprised how far it'll get you. You know, I don't, you know, whatever else have you. I don't know what the practice of law is like, you know, couldn't tell you, but at least in my day, you know, funny how you could win by telling the truth. That's a pretty good trick. Not bad. Okay, any questions about shepherdizing? Okay, again, I do want to remind you, again, it's something a lot of attorneys do not do. But chances are you won't be writing any kind of motion or documents the same day you turn them in. Just check it one last time, just to make sure. I know 2 attorneys who really, really, really wish they did that. So it never happened to me though. I have to admit, it never happened to me. So, of course, why is that?
Sure,
He's a
amazing.
gentleman. That's why. Me?
Yeah.
Oh, I was the most amazing lawyer of all time.
Damn straight.
That's true.
That's
The
what
only
you
thing I
always
was
say
better
about
at
yourself.
was,
That's what you always say about yourself.
I do?
No, I'm just saying, that's what
Oh,
that's what you always say about yourself, is I was the best.
I was gonna say, you don't go to my cocktail party. That's when it's fun, when you talk about, oh my God. One day I'll talk about all the bad stuff that happened as a lawyer. Oh my God, there's tons of it. There were some nights I'd go to sleep like, well, I'm gonna go to law school. This, And then there's just I used to call them the Salvador Dali moments. It's like, you've got to be kidding me. This can't be happening. It's so surreal. Man, being a lawyer is, I'll tell you the truth. There's going to be good days and bad days. That's it, man. I got used to it. But, it's very rewarding at times. I have to say, sometimes I think back about my lawyering. It's very, very rewarding sometimes. Not so much the arguing with the other side. That was always boring. But sometimes, a lot of the stuff is kind of cool, to tell you the truth. So, that's all things. All right, moving forward. We had an assignment, did we not?
Mm-hmm.
All right, so let's talk about that. Let's go ahead and talk about your assignment. So again, you've briefed. Have you ever briefed it? I mean, you've briefed cases here, but have you ever actually had to go out into the wild world? You do that here, right? From time to time?
Here? No,
Here,
it didn't
no.
work.
Oh, no, not Okay, again, I'm not.
Where they're just like, go find this case and brief it?
Here, we've never learned how to, we don't know the parts of a memo. We don't know the parts
Oh,
of
we're
a
doing
brief.
that next week.
We don't, yeah.
Next week is memo and all
Okay.
that kind of stuff.
I mean, I've done that stuff, but not here,
Yeah, next week is memo and basic writing. Yeah. So,
But yeah, no, as far as them just giving us a case name and say, go brief this, other than if it's in a book.
yeah, and you've never had any assignments that have asked you to do this before, go out and sort of. It wouldn't shock me if you didn't. I'm just saying.
I'm sorry, what are you asking?
Like, have we read this kind of an assignment where they just give
Yeah,
us a
where
list of
you-
cases and say,
You're responsible to do your own research, is what I'm saying, and then brief the case.
No.
Okay, so good you got it. This is, good stuff. Anyways, yeah, again, you gotta know how to do this. You never know what you're gonna get. And I think to some degree, I like this assignment just because it's very indicative of all the different places you might want to look for something, and be able to kind of, distill it down for somebody and then, you can argue like that. Anyway, so, in no particular order, please speak up if you wish to do so, but who can brief, and tell me how you found it, by the way. Now, most of you put it in Google. But here's the good news. Found it, didn't you?
what?
You found it, right?
Yeah, it's a-
All right, here you go. So what was State versus Wardley about? What was that case about? Notice the citations, see the first one there, SC, what does that mean?
South Carolina.
Very good, what's SC2?
The Southern District, or
Your Southern,
Southeastern District.
Very good. Okay, so you see, here's your double citations. One is the local, one's the national. Yeah, okay.
Alright, so basically, this guy was in a prison camp. He got sick with poison ivy and had a lot of issues, asked for help. They said no, so he finally ran away.
Yes.
And
Very good.
got help, but he was gone for 2 years. And so he got caught, got brought back. During his trial, he wanted to have the defense of necessity, and the trial court said no. So he appealed it because the trial court refused to allow the defense of necessity. And so the issue was, when a defendant who contends he escaped from lawful confinement due to inadequate medical treatment is he entitled to have the affirmative defense of necessity submitted to the jury? And the rule was basically, yes, he is allowed to, but only if there are 6 different prongs that have to be met, which are basically, he informed them either in writing or if somebody admits it. There must not have been time to go to the courts. The escape must have been without use of threat or force. The escapee must promptly seek medical treatment. The treating physician must testify that he was actually in danger of death or imminent bodily injury, and after he's cured, he has to go back.
So what did our
And he did not go back until he was caught 2 years later, so they said, yeah, you may have been able to argue it, but since you were gone for so long, it doesn't really matter because there's no way you could meet the prongs, so enjoy your extra year.
We're done. That's it. Interesting case about prison necessity. They lay out the rule for you, and unfortunately, this fellow did not come back after his treatment. So they found, although it is possible, he didn't qualify. It's kind of an interesting case, you know, whatever it's worth. Okay, Berger versus City of Seattle. This is actually a case that I've used that I find really interesting.
This is,
Right, we've got this federal thing going on here now. Right, so even though it happened in Seattle, can we use it in California?
Kind of.
probably.
Sure, it's in the Ninth Circuit.
Yeah, something like that. So if it's just within the Ninth Circuit, but you're not within that state, is that a primary source or is it still secondary? Because it applies to your judicial district, but it's not your jurisdiction.
I believe it still is primary because it's a federal Ninth Circuit court case. So I believe you can use it as primary, although I like.
And that's only if it uses
They're all-
federal law, right?
They're all
Like, it's a federal
primary.
question.
The question is if it's mandatory.
Yeah, but I thought if it's not within your jurisdiction, it becomes secondary.
No,
because
no, no.
It's not persuasive.
Any statute, any case is primary authority. The question is, does your court, how much
Oh,
does
is it
your court
binding?
care about it? Right? So if it's from like the Second District of California, they're probably gonna just follow it.
Yeah.
You know what I mean? But if it's
Like
from
Maine.
Oklahoma, they're probably not gonna
Not
follow
at all,
it. Yeah, you know what I'm saying?
But it's still primary, even if it's from a different state.
Yes, because primary just,
It's just not binding.
it just talks about yes.
I think the problem is what they'll do is, because remember, they are interpreting, at its very core, they are interpreting Washington law, but it's for the circuit, so I believe it is binding. So, yeah. I mean, they may point out something like, well, California doesn't really have that law. I mean, it is possible, you know, but on the other hand, this is the Ninth Circuit. So,
I'm pretty sure that you're right. I think that it would go, it's California Supreme Court cases, then it's United States Supreme Court cases, then California cases from top to bottom,
Right.
and then it's
For
federal.
that circuit.
so
or
I'm
any
saying they
circuit.
might look at.
And then you might step out of.
So like do Ninth Circuit and then any circuit and
Oh,
then,
then the district courts. Yeah.
oh yeah, the district courts.
Well, the district courts are higher than the federal courts for a state issue.
Oh, because it's a state issue. Yeah, well that's what I was trying to get at. I mean, at least with the Ninth Circuit, it's a federal issue, so therefore it's kind of binding within the Ninth Circuit. But if it was a state-driven issue, like a state law issue within or not Seattle, but Oregon or Washington.
Well, this isn't Washington.
Washington. Then it's basically just a Washington, and it's persuasive, but
I still think because this is in the ninth,
it's still fine.
and they're saying, well, this is the law that applies in the Ninth Circuit. You know,
Okay.
so it's like, you can definitely use it. I do think it is, it is, in my mind, it's primary. But they will say something like, no. They are allowed to do that. I mean, they'll say something like, well, why are you quoting Alaska law? It's like, well, there is no law. I mean, there's all sorts of different reasons why. But yeah, you definitely, no worries. You can definitely throw it in. No judges.
As long as you explain why.
Or anything. You might use it for explanation purposes too. You can always say stuff like, you know, they're really smart up in Washington. You know, pretty smart. You know, you can actually say something like that. I don't know how much would carry. But yeah, I mean, federal law is primary. You can't really get around that. But again, you know, everyone's, you know, Ninth Circuit, California, really. Anyways, for Seattle. Okay, thank you.
Berger's a street performer. He's making balloon animals for the kids and telling them how important it is to read. The city says, we can't do this anymore. You're gonna have to have a permit. You're gonna have to wear a name tag. You're gonna have to do all kinds of things to be able to perform.
Very good.
And then, he fights it and he wins. He gets like $1 nominal attorney's fees. But then the state argues, well, this was like what we learned, a content neutral restriction. Right? So they did that whole three-pronged thing where it was
The First Amendment issue. Very good.
it must it's content neutral, it must be narrowly tailored, and they must leave open alternatives to be able to do the performance. And yeah, they met those 3 prongs and they reversed their amendment.
Good. I've actually used that case. So I didn't know the First Amendment thing I had once. And it was a really interesting case. Part of why I also put this on your assignment is because, the case behind the case, I did my research just to show you. And it's really very, very interesting, though, much more than you might think. Because you sit there and you say to yourself, well, why are they picking on this street performer? If you read the case, you might say that, right? You might say, what the hell?
That's homeless people.
But here was the deal, though, which is really that's so close, it's scary.
It's true, though.
The thing is, the problem they were having 2 problems. One, the sort of minor one, was that homeless people would also gather there and really bother patrons. So that was kind of a problem. And some of the street persons themselves, who even knows. But here was the bigger problem, if you can believe this, is that the performers were actually getting into violence over who would get certain spots, because certain spots were more desirable than others. And they made this one point, it was really interesting, that there was this one spot that everybody wanted because there was this guy who would all he would do is play violin. He was this violin, actually apparently pretty good. And he'd play all these classical violin things. And how much money a day would he make in this spot?
Probably a lot.
$300. You can make up to $300 a day. Well, of course, when the other performers found out about that, what happened?
They want that spot.
They would actually have turf wars, and they would actually be acts of violence against these people. So that's actually where the case came from.
They talked about that in the case, about the state's reasonings for having them.
Yeah, I mean, they were literally preventing acts of violence. Bad ones. I mean, this is not bad. They were really hurting people and stuff like that.
But is it true about the badge aspect that the badge interferes with somebody's First Amendment right because it hampers their costume?
I don't know about that.
I mean, they talked about that in the case and how there was authority for it and stuff like that, but it's mind-boggling that mandating to have like a badge hanging off your costume hampers your First Amendment rights because it just seems like a stretch.
I mean, you know what you may remember you may remember what I always say about such cases. Maybe we can sort of track it back, but all roads lead to nude dancing. What the hell is this doing in my book? I kind of see those the same way. It's like, yeah, technically they're right, but
Okay.
I don't know. I mean, again,
I just saw it and I was kind of amazed by that.
Well, but what about tradition? Have street performers traditionally been made to sign up and wear the book?
No.
I think that's what I got out of the case is that you were kind of saying, this is traditionally not what we do. And I don't know about the interfering with, well, it kind of does. It's sort of the state in new dancing. I don't know.
No costume, but no badges.
Yeah.
The no costume is your
I think
costume.
and the new dancing one is a great comparison because where was the badge going to be? But that's
a necklace.
But that's why you gotta love con law. I mean, it sounds funny, but this is what I love about con law to some degree. It's how they get into these. It's like, really? This is what we want the courts to do? Okay. It just, don't you wish, just very quickly, don't you wish that we just had a Supreme Court? Whatever they rule. Don't you just wish the decisions were like 9-0, 3 words, let's go move on?
Yeah. Now that I'm in law school, I
How
wish they
different-
were like
How
that.
different would the world be? We wouldn't be sitting around. And that's what, and you do understand it for hundreds of, most of our history, the courts have been 9-0, 8-1. 7-2 was, 6-3, wow. 5-4 was unheard of. Hundreds of years. Just was, I mean, can't say it never happened, but you know, it was always considered that the court would have consistency. The court would give us guidance, not just for today, but for many generations to come. And the court decisions were routinely 9-0, routinely 8-1. What we're going through today is actually quite unusual. Very unusual when we have an entire age where the court is 5-4 all the time. Very rare. Actually, you can't find too many other times in our history that was true. So again, that's what I kind of think about with some of these cases is you got 2 minutes of time on your hands. You know, just give me the decision, stamp it at 9-0. I don't have to worry about it again. You know, would life be different? For lawyers, it would be. For the average citizen, probably. Yeah. You know, you wouldn't get up every day thinking I'm going to go out and protest tomorrow. Good, bad, or indifferent. Suit yourself. You know, it ain't going to change tomorrow. I mean, nothing.
Yeah.
But 5-4, you know, who knows, right? I don't know, just something to think about, you know, sometimes as long as you're lawyers and stuff like that. 5-4, help our country or hurt our country? In my opinion, it hurts. Again, I'd rather just have the decision, right? 9-0. I'm not going to go around swaying 5 people anytime soon, you know, for better or for worse. But that, again, that's just me. That's just me waxing and waning philosophically about the Supreme Court. And they never do that, you know that.
Never.
Never do I ever talk about anything ethereal. Okay, Brunette versus City of Columbus. Here we are in the federal supplement. What does that mean? We're in South
The district court.
Southern District Court of Ohio. So what's Saley in Ohio?
Okay, so in this case, the plaintiffs are women challenging the test used by the city of Columbus to select entry-level firefighters. There are 2 batteries of tests. There's 4 written subtests, a reading comprehension, and mechanical reasoning, 2 psych tests, and there's a physical component which has 7 events, 6 which are scored, and the written components were 70%, and the physical tests were 30%, and those 2 written components are 35% each. I mean, obviously the psychs aren't scored, so it's just the reading comp, the mechanical, and then which are 35% each, and 30% is the 6 scored physical tests. Okay, so during the lifetime of these tests, 109 applicants were appointed as firefighters. Only 4 of them were females, and the plaintiffs are challenging 2 components, specifically the physical tests, all of them, and the mechanical reasoning portion of the written test.
Okay.
So the procedural history is they brought the action for discriminatory practice under Title VII of the Civil Rights Act of '64. That's 42 U.S.C. 2000. They seek injunctive relief and back pay. They contend that there is a city the tests employed by the city have an adverse impact on female applicants and are not job related. The issue here is whether the tests used by the defendants to select firefighters complies with Title IX, and the rule is Title VII forbids the use of employment tests that are discriminatory in effect unless the employer meets, quote, the burden of showing that any given requirement has a manifest relationship to the employment in question.
Nice.
And they cited that from Griggs versus Duke Power.
Okay.
Now, they went through both years and all those tests. It was a very long case. So there's a burden shift going on here where the complaining party has to show a prima facie case of discrimination, and then they need to show that their tests, then the city can show that their tests are so related to the job that the discrimination is appropriate. In the end, they found that the 1984 tests were not significantly related to the job, and some of the tests were put through this rule, and some of this were not. And there was,
Okay. Good job. Yeah. Again, I kind of like this case personally because if you remember from common law, we talked about Washington versus Davis. and its progeny. Remember the one about the police officers?
Mhm.
Yeah, this is one of the progeny cases that came after it. So if y'all think of mine in this class, guess what? I'm in line. There it is for you. Okay, good job. Very good. Okay, love this case. Reed versus King. Now, this is again another case that I actually had to look up myself one day to figure out the actual answer because I didn't know. Somebody asked me this.
You have to look up the murder house case?
Murder house. This is great stuff.
So Miss Reed's a little old lady. She buys a house from Mr. King. However, Mr. King nor his agent informed Miss Reed that a woman and her 4 children were murdered in the house 10 years earlier. She was actually, it was represented to her that it was actually a nice house that was fit for an elderly lady that was in good condition. She paid $76,000 for the house, and it came out that with its history, the house was actually only worth $65,000. She found out after she bought the house that it was a murder house from the neighbors, who Mr. King had actually asked to not disclose that it was a murder house.
That's nice, huh?
Yeah. So she learned of the murders and she sued Mr. King for rescission of the contract and just damages. So the issue that I had, which I think is wrong, but is in the sale of a house, must the seller disclose it was the site of multiple murders? But it kind of dovetails into is withholding the fact that somebody was murdered in your house a concealment of a material fact for a fraud claim.
With more of a tort.
Yes.
Very good.
So the rule that I had was the 5 different parts of bringing a action based on fraud, and the court here said that if the buyer can prove at trial that A, they wouldn't have bought the house if they knew, and B, that the murders actually have an impact on the purchase price of the house, then it does become a matter that's a concealment of material fact, because the court said it is not on the buyer to research the criminal history of the house, basically. And so that's on the seller to disclose if it's known about to them.
Very good. Yeah, had to look that up for someone. I've worked with realtors over the years.
We had that in a conference first year.
Did you really?
Was it?
Love it.
I don't remember that case.
And here's an interesting question though, which you're welcome to go and research if you so desire. I won't tell you the actual answer. Is it actually possible that if a murder was taking place in a house, it could add value to the house?
Yeah.
Possible. How about a ghost story? Could it add value to the house? Possible. So you got to really look at, the bottom line is what? Value of the house. How does it affect the value of the house? Now, of course, if you're going to sell something as a ghost house,
Better be a ghost.
you can get $10,000 more for it, then why wouldn't you tell them, right? So it's more of a disclosure.
And my grandfather almost bought the Amityville Horror House.
Oh, no way, really? Oh, that's cool.
But my mom and my aunts and my grandma all told him no way in hell are we ever living in the house.
Oh,
but they almost bought it because it was such a great deal. Which, because it's the Amityville Horror House.
okay. Okay, that's in New York, though, right?
Yeah, it's in Long Island.
Long Island? Okay, yeah. Because a friend of mine tried to buy the, and it changes hands all the time. It's kind of a weird story. But they think they know who really killed the Black Dahlia. You've heard that story here, right? You ever heard about the Black Dahlia? Oh, he died. I tell you what, go look up Black Dahlia. We'll talk about it next week.
Okay.
Okay, it's one of the most it's one of the most infamous unsolved cases in Los Angeles history. And a friend of mine actually did a huge book on it. It's really fascinating. Anyways, the guy who they think actually did murder the Black Dahlia, his house goes up for sale. It's in secret, and it just every time it hits the market, it goes in 5 seconds. People can't get enough of it here. When I lived there, hell yeah, it's beautiful, man. You gotta see the house. Okay, good job. This case, New Jersey versus New York. It answers one of those questions that nobody ever seems to know the actual answer to.
Because nobody cares, except for New Jersey and New York.
Unless you're in.
Yeah, unless you're on the tax rules of New Jersey or New York.
I don't care. I'm trying to, right. Go ahead.
So New Jersey and New York are having a dispute over land.
What land?
There's the land under the river, the waterway that they're sharing.
Well, it's Ellis Island.
Oh, I know, it sounds like I was getting there.
Yeah.
Right.
Because that's how it starts. That's how it starts, right? So they're arguing, so pretty much New York has the rights to the waterway and the land masses on top.
Okay.
But, New Jersey has the rights to the water line and below everything.
Okay.
So then what happened to Ellis Island is that they built it up, like the federal government took over and they built it up, they made it bigger. So they added all this new land that was on top of New Jersey land under the water. So it's built up now to be part of the island.
Okay. Good.
So now their argument is, well, who owns this new, bigger, this island? New York trying to say we own the entire landmass.
Right.
But as the contract was originally written, well, New Jersey owns everything in the bottom. You just have to build on top of their land that they already owned. So the way Ellis Island is split up now is New York owns the original landmass, and all the additions that are built around it belong to New Jersey because they own the underwater part of the waterway there.
Okay. Not bad. Yeah, it was pretty good. Again, it was kind of a weird, raging controversy as who actually owned Ellis Island, but particularly Ellis Island is really broken into two parts. Just so you know, part of it was the admissions part, and then the other part was the health clinics and everything. And the question really was who owns the buildings. I mean, that's really who owns Ellis Island, And for many, many years, New York claimed the entire thing. Finally, after many, I hope you caught that, many, many years in court cases, they finally decided, well, to be perfectly blunt, most of it is actually owned by New Jersey, actually. Strange enough. There is a part that still is owned by New York, and they base it on this ancient kind of, how did you break down the stuff? And so I don't know what that's, as a practical matter, I'm not exactly sure what that's meant to New Jersey. I'm not 100%.
I always thought just the federal government owned Ellis Island and Liberty Island and all those little islands within the New York Sound.
But
they don't.
See, they kind of own the immigration center because that's federal. Although they don't do it anymore. They just know it. Does anyone still come to Ellis? No, of course not. So, but it's interesting that they sort of, so now what do we do? Same thing with Alcatraz, because the rule is, that if, in fact, the federal government actually has land and it stops using it for any particular person, it goes back somewhere. In other words, the federal government has to use land it acquires. And so it just so happens that particularly with like Alcatraz, it's like, they stopped using it for a federal purpose and the tribes claimed it. They said it was originally tribal land, and I don't know, it's the funniest thing. When I was a kid, I was actually in San Francisco at the wharf watching tribal members go on boats off to Alcatraz. I was actually there as a kid, and I, of course, I understood nothing what was going on, but I thought it was cool at the time, to be honest with you. I'm like, wow, they wanted to live on Alcatraz? And so, of course, they turned off the electricity, they turned off the water. And they stayed anyways, but they went through the courts and they found that, actually, to be honest with you, the federal government kind of said, yeah, we're not using it now, but we will. So the tribes lost. They didn't get Alcatraz back. But the actual theory is, again, it's kind of interesting because here we are out in the tribal world too, is that the federal government claims tribal land, but then does not use it. Theoretically, it goes back to the tribes. That's actually true. Kind of interesting. Anyways, so that's that case for, but that was New York, New Jersey. Good job. U.S. Constitution amended, X1V, Section 1. What's that now?
This is Section 1 of the 14th Amendment of the U.S. Constitution. As we know, it has 4 clauses. Versus all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. 2, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, and nor deny any person within its jurisdiction the equal protection of the law. So in the In the Civil War, we have, this is one of the like, three, and these are the privileges and immunities, due process, equal protection, and the citizenry, just in one little part.
Very good. Okay, so that's why, good, first of all. And second of all, when people ask you all these things like, well, the founders, da 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 da, it's like, the founders didn't have the 14th Amendment, so maybe you should think about those rights. That's why I throw that in for you. I actually had to make that argument the other day. Well, you know, the founding fathers, these are called the secondary framers. 13th, 14th, 15th Amendment, remember those? They're still on the books. Might use that argument someday. And again, it's all in the same place, right? Privileges and immunities, due process, equal protection under the law. You know, these are the laws of the land. You know, why didn't Washington use them? They didn't have them. But they're there, right? You have a civil war, you better do something to stop the next one. Just my opinion. Good job. Okay, 42 USC. 405, lots and lots of little numbers and clauses after it.
You want me to read it all?
Nah, just tell me.
It's about birth certificates and getting a birth certificate and how to get a social security number and all that fun stuff.
So now when someone asks you, you know how.
No, I still don't know how, but yeah. I have a baby and the hospital does it all for me.
Okay, good deal. So when people say, well, how does that work? 42 USA, bro. You get those things, I'm just telling you. This is one I like a lot. Cincinnati, Ohio, again. Municipal code means some kind of code for the city or something. What's that all about?
I didn't really get it. I mean, I was gonna say how I found it. I just Googled, the Cincinnati Municipal Code. It took me to their website, which all their code is available for free online. So, and I just searched for 302 and I found the notice of property owners.
Yep. Very good.
So it's a lot of, I don't know, we need, the city treasurer shall as far as possible cause the place of residence to be ascertained of every owner whose property is charged with special assignments of any kind as soon as the treasurer's office shall receive notice thereof of the place of the residence of any successor title and shall not the same assignment record the treasurer's office. So it sounds like they gotta give the new buyers notice of what restrictions they want.
Pretty much, yeah.
That's kind of what I got.
Again, another really oddity that I had to look up one day, and it's always people think, lawyers think they don't have to look these things up. Sometimes you do. You know, I one time I was asked to do title on a specific part of land. I don't know why they came to me, but it was in Pennsylvania. Did they come to me? I don't know, because anybody can do it. That's actually why. But I had to go all the way back to that, and to me it was, I never knew I was going to have as much fun as I did. I went back all the way to a deed that was written by a quill. You can actually do that in places like Pennsylvania, you know, by the hand of William Penn II. Whoa, that's cool. And they're like, yeah, can I buy the land or not? Well, yeah, they're dead. And, they passed it on. So be it. But I did go all the way back to a document that was written in quill. You can do that. Wow. Good thing it was online. You know, microfiche online or something. All right, HR 2971. 108th Congress. Not that far ago.
So this
What is that?
Hearing 2,971 of the 108th Congress, which took place in 2003. This is section 101, and it describes when the government can give somebody your social security number.
Right. Very good.
The
Very practical stuff.
general rule is that they can't. And there are 7 exceptions. If authorized under this act, 2, for law enforcement for law enforcement or national security purposes, 3, to comply with federal or state tax law, 4, the DMV needs it, 5, consumer reporting agencies for specific permissible purposes, 6, non-market research conducted by another such agency for advancing the public good under certain conditions, including privacy safeguards, and 7, for display to the general public under certain circumstances to be specified in the relevant. So they can't just give anybody your social security number unless they have a rule that says they can.
And again, I've been asked over the years about social security numbers and stuff. I mean, you're a lawyer, you know that, right? All of you know about social security numbers, right? You're a lawyer,
Oh, yeah.
of course, all lawyers know about them. Do I look like a walking code section? No, but I will look it up for you and turn up to there. This one also answers another question when you start looking at HRs and stuff like that. Is the other question you will get, maybe not so lawyer, but colloquially, is what was Congress thinking? Now you know. Read the notes, you know. It's there if you want to go look these things up. You know, sometimes it's really interesting to look up the notes and stuff like that. They'll tell you what they were thinking and why, quite often.
They weren't. They had 2 hours to read 3,500 pages, and they said, yes, this is good law.
And they asked the whip, who's advised by a party policy lawyer, and they followed that person's
They're paying $3.5 million to their re-election campaign to do it.
Similar generation. Not saying you're wrong. Oh, and then last but not least, and as you put it out, yeah, it's even more.
NAFTA. It doesn't matter anymore, so that's what I gotta say.
But it also answers the question, you know? When people ask you what's in NAFTA, can you find out?
By that. Well, no, not anymore. It's off the government website.
A little tougher now.
Yeah.
But I mean,
You just can't be sure, you just can't cite it.
People always say to me, well, what's in that? I say, you can look it up. I mean, stuff like that. And again, it's an obscure part of conditions and stuff like that. But if you wanted to know about it,
Is it technically still law?
yes, NAFTA's still all right. They're still working under NAFTA. And to be honest with you, if Trump tries to change it, they'll probably have a lawsuit.
Didn't he already change it? Isn't that because I thought he raised.
He tried to the other day, but he still doesn't have it on his side, so they've made no actual decision.
Well, no, I thought the whole point of redrafting NAFTA was because he increased tariffs on dairy like 20% or something like that.
No, you did aluminum and steel.
I know he did aluminum.
In reaction
That
to
actually
the exception, which
NAFTA
is
would
like.
Oh, I thought that he had done something to NAFTA.
No, not yet. Well, he did theoretically.
Well, yeah, 'cause
Announced
he's
that he had renegotiated.
Renegotiating it with Mexico.
Mexico, but he still needs Canada to sign on, and they're just. Right now, NAFTA's still good. Now, whether he puts that on his website or not.
They're not.
Good job, okay, you guys did really good.
Yeah.
Real good, okay, we're off to a great start to this class. Okay, again, I guess what I'll do, again, is on Saturday, I'll give you your assignments for next week. But next week is memo. So, of course, you know, how to do that.
So we'll get our homework on Saturday.
I'll give it to you on Saturday, I'll
Okay.
just give you the paper copies.
Great. Thank you so much. Awesome. Thank you.
Just a copy for my research.
Yeah, just do whatever you want to do with it. Go take it in, it's fine, it's too much straight in. Yeah, go have a listen.
Give it a listen.
That's what he did. No wonder they only, you know.
You'd be surprised, I like some weird reasons.
I could only hope. But yeah.
Looking at the artwork on the website, it sounds like something I'm just doing.
Well, you know, I'm an art major and I absolutely adored Russian artwork around at that time.
Is that what
It's called superlative work.